Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are turning our sights to Alicia Andrews. She is scheduled to have a hearing today to see if she will get a new trial. We are fingers crossed, hoping that Judge Fernandez joining us today streams it. It's still up in the air, but we have plenty of content for you guys. Regardless, if she shows it, fantastic. If she doesn't, don't worry. We have stuff I guarantee you've never seen before. So with that, get comfortable, settle in, and let's get started.
Up where I left off, ready, I'ma pass you the phone, say a damn line. Is it just me or the vibe been steady going down? When with you I'ma save mine. Took me so long, figure out what you want. Every time you're with me, it's a great time. Only way you reach out is with your hand in my pants. You unbuckling, so I gotta go. See what I move from a distance. I got so cool, you got chills. Not what you used to, I'm different. You ain't getting in my feels. You should know with me, only got one chance. Went behind my back and blew it. Shit is not my style, keep it so low-key. What I do, don't need to prove it. One thing about me that I know for sure, you will never see me lose it. Never see me lose it. Never, no.
All right. Good morning, everybody. Hope everyone is doing well today. It is Friday, May 22nd, 2026. And hope you guys are all having a good Friday so far. We have Horse Welfare, Hector's mom, Crazy Mary Fitz, going to be lurking today. No problem. Hey, Allison, morning from Scotland. Christine, good to see you. Terry, Trial Watcher, good morning to you. Elaine, going to miss the first 2 hours. All right. No problem there. Wolfresco, good morning to you for baby's mom. Good to see you. JMS, welcome in. Surfing Selena, hope you're hanging 10 today. Kimbers, good morning. Happy Friday and a 3-day weekend ahead. Yes. Linda, good morning to you. Good vibes only, saying hello to everybody. Debbie, good morning to you and thank you for your $4. Appreciate that. Let's see. Let me scroll. Snap, there you are. Good morning. Good morning. Iowa Backyard Cam, good morning. It's a rainy start to today. Will it rain all day? We need the rain down here. Hellrider, how are you? I know you need the rain too, where you are. Yeah, we need rain. We had a little bit yesterday, like a little, just enough to make everything humid. Not enough. We definitely need more rain. Kaylee, good morning to you. Good to see you. Heidi, good to see you. YT Hazel, good morning. Good morning. Welcome in. Truth Hurts, how are you? Good to see you. Appreciate you joining us. Let me just scroll up here. Gordon, good to see you. Bama Green Eyes, good morning. Val Cork. Shirley Roth, good to see you. John Colmar, North Carolina, welcome in. Marcia Bright from New Orleans, good to see you. Bama Green Eyes, hello, hello. KS Granny, good morning to you. Joe and Jedi Platypus, hello. Hey, Anthony, how are you? Good to see you. Tink, welcome in. Let's see. Jenny, is Jenny with us? There you are. Good morning, Jenny. Good to see you and the McCormick family. Hope you guys are doing well. All right, I think I got everybody. No comparison. Nice. I wish they would retry her for all if they claim it wasn't fair. Redo it all. Yes, I know they can't. Green-eyed cat. Good morning. Sod girl. What time does the trial? 8:30. Bottom of the hour. Bottom of the hour. Another 10 minutes. Dairy-free nomad. Good afternoon from sunny UK. Beautiful day in Birmingham. Harish. Good morning, or good afternoon then to you. Hey, Beach Mom, good to see you. Happy Friday to you. All right, so let's get everybody get comfortable. Right now, we are waiting for Judge Fernandez to open up the stream. So it's going to be, we won't know until, I don't know, we won't know until 8:30 Eastern, which is another 10 minutes. So fingers crossed, we have our eyes on a couple different sources. The big channels we're watching, some smaller channels, some what do you call it? Local news. So we're hoping something kicks in. And if not, we have some pretrial hearings that I know you guys haven't seen. I guarantee you haven't seen this. So we've got, I think maybe 5 or 6. Excuse me. We have some pretrial hearings that we're going to show you guys. I'll also read through some of the motions. I read through them 2 weeks ago. I'm not going to read through all of them, but let's just get started with Alicia Andrews. She was convicted Halloween night, October 31st of last year, 2025. She was convicted of manslaughter, which was the lesser charge in the shooting death of Charles Jones, who goes by the name of Julio Foolio, and that was on June 23rd of 2024. Now, Michelle Sisco, who I'm sure you guys are very familiar with, was her trial judge. She was also the trial judge for the other four defendants, Rashad, Davion, Isaiah, and Sean. So Alicia's team successfully was able to remove Judge Sisco, and we showed yesterday's stream. If you didn't see that, I encourage you to go back and watch some of that. We kind of did this exercise. We took clips of interactions and sidebars and objections and all that to see if Judge Sisco was indeed being biased. I personally didn't really see anything. I think chat generally, you guys didn't see that either. But her defense team was successful in removing Judge Sisco from her sentencing, which would have been December 8th of last year. And if you're following along there, they did a motion to stay the proceedings on December 4th, and they were able to stay that sentencing, got it over to an appellate court, and the District Court of Appeals on January 27th of 2026 actually removed Judge Sisco from the sentencing. So then the new judge was appointed. You see February 4th, Judge Kimberly Fernandez was appointed, and that's where we stand. That's where we stand right now. So we are absolutely fingers crossed that we have a stream for you guys. And again, if not, we have some hearings we can show that I'm almost positive you guys have not seen some of these. So we were just able to locate them the other day. So I'm looking forward to watching that. Even though the trial's over, it's still good. I want to have it in our library. So if we do not have a stream, we will do that. And I'll go ahead and I'll read some of these motions because I think that's important as well. So let's see. We have a poll. Will Alicia be granted a new trial? So far, 38% of you are saying absolutely yes. 62% of you are saying no way. So if you haven't taken our poll, also hit the like button if you don't mind. That show us that you are a human being and not a bot. We would appreciate that. And we are, let's see, waiting for something to kick in here. Again, there's no guarantee. I'm going to just say that straight away. There's no guarantee that we are going to have a stream today of the hearing. Everything has to do with Judge Fernandez. So none of the large channels are covering it. So it's not looking good from that standpoint. However, we do have a couple other resources. We do have a couple other resources that we will be able to tap into to see if indeed she is going to stream it. Because it all depends on Judge Fernandez. Rob Christopher, good morning to you. Good to see you. Thank you for joining us. Appreciate that. Yes, hit the like button. Hey, Wizard of Ezzy, good to see you. Appreciate you joining us. For Baby's Mom, hello, hello. Val Cork, great way to start the weekend. Yes, appreciate that. Thank you for spending your Friday evening with us. Well, for you, it'd be afternoon, right? What is it, about 1 o'clock for you guys? Over the pond? So we'll know, it's supposed to start at 8:30. So let me bring us over here. We'll just plop us there. And let's see, will she get a new trial? Will she get a new trial? Hey, Joy, good morning to you. How are you? Great to see you. Amber Fox, are you with us too? I see people saying hello to you. John Doe, she should get the same punishment that the other four got. I would say at least with Isaiah. I mean, her and Isaiah were in the same car. You know, again, we watched clips yesterday. We watched snippets, and then we watched Robert Howard, and then we watched her testimony again. It's like the second time I think I've seen it full all the way through. And then probably another 4 or 5 times I've seen clips here and there. If Isaiah got life without parole, yeah. But the jury thought otherwise. So the jury thought otherwise. Hey, Ruth Ann, good to see you. Got manners? Hello, hello. Hope you are doing well. Happy Friday. And definitely don't forget to hit the like button. There you are, Amber. Good morning to you. All right. Wizard says, I watched yesterday in part of the original trial. I've got issues with the motion for new trial, and that is citing chatters in a stream about Sisco. Yeah, that's, we covered that 2 weeks ago when we thought we would have a stream and then they, hearing, and then they kicked it to today. The defense absolutely cited Court TV, long crime. People in those chats were saying, judge is biased, and the appellate courts, the judges looked at that and they decided, yeah, it was true. So, hey Nick, how are you? You're in the UK. Week-long heat wave. Screaming Daisies, good morning to you. Hey Dusty's Music, good to see you. All right, so again, we are just waiting. We still have 2 more minutes before they have to do anything or before they're scheduled to do anything. So let's just see. We're waiting. And again, there's no guarantee. I'm just going to let you guys know that right now. That there's no guarantee that A, it'll be streamed, and B, we'll be able to watch it. So if we cannot, I've got some pretrial hearings that I've never seen before. I'm pretty sure you guys have never seen before that I want to show you. And again, it's just to make our library complete if we cannot watch those, if we cannot watch the proceedings. Wizard says, Sisco got frustrated with counsels, both sides, for mid-trial motions that should have been dealt with before trial and didn't see any reversible error. I personally didn't see it, from a layperson's standpoint. I saw her getting frustrated. I saw her ruling for both sides. Again, from a layperson's eyeballs, I didn't see anything. Hey, Florida PI Sam, you're home. You'll be listening, probably not chatting, but saying hello to everybody. Glad you made it home safely and sound. I'm sure Henry is happy about that, as well as you are. Elspeth, good morning to you. Great to see you. Thank you for joining us. UK is sunny today. Got Manners says. Denisha, I was looking for you last night. I thought you were going to do the launch. Was it? Nope, totally missed that. Totally missed that launch. So that's on me. Totally missed that. All right, it's 8:30 here on the East Coast. We are waiting to see. Hey, Richard in the kitchen. Good morning to you. Good to see you. Let's see. Wizard says, by citing chat, there's no way to cross-examine the poster for bias, and unlike a witness, people are behind handles and unless subpoenaed by the court. Yeah, totally agree. Totally agree. CC123, good morning to you. Good to see you. Oh, the launch was canceled. I am like so far behind on that, you guys. I have not even had the head to think about that. Let's see. Evansky, the USB stick ruling was biased. Not familiar with that one. Let's see. No comparison. Judge Sisco is very respected here in Tampa. She wasn't biased. She was trying to control her courtroom. There was way too much going on. UT Texas, the rocket was a no-go. Okay, thanks guys. I gotta put my head around that. I'll keep my eyes out for that because we'll cover that. I'll look at that over the weekend to see what the next steps are for that. All right. So I'm just checking a couple sources. Nothing there. So we're waiting for Judge Fernandez to possibly allow this hearing, I should say, to be streamed. So it may or it may not be streamed. We're just going to have to wait and see. But like I said, I've got some pretrial hearings to show you guys if in fact it is not streamed. So we will definitely do that today. Couldn't care less. Good morning to you. Good to see you. No sleep till Brooklyn. Yes, Hellrider. Tentative relaunch today at 5:30. Gotcha. Okay. I'm not even sure if I'll be able to deal with that. But thank you for that. I'll take a look at that. I'll take a look into that. Right now, my head is around is Alicia Andrews right now, trying to get this stream for you guys. So I will take a look at that if and when this actually starts and kicks in. Because right now, we are not seeing anything. Jane Dixon, Mama C, good morning. Good morning. Couldn't care unless you can't tag anybody. No problem. Luxury Mama, how are you? Good morning. Does the new judge not like streaming? Have no idea. I have no idea. We're hoping she does. We're hoping she does. I've got another source, but they're not showing it either. So we'll give it a few minutes because sometimes we've discovered a lot of times actually they're not on time. But this is she may have something else on the docket. She may have something else. What we will do is I'll give it about 15 minutes or so, and then I'll start to show some other things. And if she does kick in, we can always bounce over to that. So we're not going to give up on it. We'll spend at least 3 or 4 hours kind of going through some pretrial stuff. And if it kicks in, and we'll grab it. Ava Renee, good morning to you. Good to see you. Got manners. Alicia spent most of the trial writing. That she did. That she did. We watched it. And Robert Howard's testimony, I don't think she even looked up at him once. I don't think she looked at him once, to be quite honest. So all right. So we'll give it a few more minutes, and then I will play some other stuff. Let's see here. Yeah, a lot of times what happens with these is that judge has multiple defendants, multiple cases that she deals with. So it's not like a trial where, you know, it's scheduled and it's set and you know when it's going to happen. So there could be 10 people in front of Alicia. You know, we just don't know because we're not there. So we have to we just have to be patient and wait. And if something kicks in, something kicks in. But I'll give it a little bit. All right. So Richard, you're seeing somebody is saying 20 minutes. All right. Well, we're here and we're ready and we're waiting. We are here and we are ready and we are waiting. How reliable is that quote unquote other channel, Richard? You have to look at it like that too. If it's a reliable channel, cool. If it's not, you know. So we just have to wait and see. So, Angelique, good morning to you. Hey, William, good to see you. Mike Morrow, welcome in. I don't want the name of the other channel, Richard. It's okay. If you want to email me, that's fine. Don't drop it in chat. If you want to email, that's fine. All right, so while we wait, let me take a look at, let me think here for a second. Debbie, thank you for the 5 Trial TV Live gifted memberships. Ooh, Denisha, you got one. Awesome. Denisha got a membership. Fantastic. Appreciate that. And yes, if you guys don't mind hitting the like button as you come in. We also have a poll going. Let's see. Richard, you just tagged me. you just tagged me. I just saw it. Hey, Kathy. Good morning to you. Yeah, you just tagged me. I saw that. I saw that come through. All right, I really don't want to do anything that's going to, oh, you had to type it out. Oh, okay, gotcha. I hope it's working now. All right, I don't want to mess with anything in case, because this connection's really fragile. So I don't want to pull up anything. I just want to wait before I do anything. Alice, good morning to you. Good to see you. Let's see. Jenny G. Let's see, I missed that. What? Can I go back and see what you... I missed that, Jenny. Yeah, I have a very fragile connection. I don't want to do anything. Well, I suppose I could read while we wait. I could do that. Let me at least read this. So this is the motion. This is from the District Court of Appeal. So this was January 27th. So petitioner's petition for a writ prohibiting Judge Michelle Sisco from presiding further in circuit court case number 24 CF 11996B is granted as the petitioner's motion to disqualify the judge filed in the circuit court is deemed legally sufficient. Accordingly, and here's one of my favorite judges, Chief Judge Christopher Sabella, we remember him, shall immediately appoint a successor judge pursuant to Florida Rule of General Practice and Judicial Administration. The stay imposed by this court's December 5th, 2025 order is lifted. So that came in January 27th. So now the motion to disqualify. So they filed this on October 31st. So they actually filed this before the jury started to deliberate, as we saw yesterday. We saw this yesterday as we were watching. They actually filed this before they got to before they even did closing arguments. Before they did closing arguments, they filed this, and the judge denied it verbally, but then she denied, or she put it in writing as well. But introduction. So defendant Alicia Andrews respectfully moves to disqualify the Honorable Michelle Sisco from presiding over this matter on grounds that her conduct and statements have created a well-founded fear that Ms. Andrews cannot receive a fair and impartial trial. Ms. Andrews stands accused of first-degree M and conspiracy in connection with the alleged ambush deletion of Jacksonville rapper Julio, quote-unquote, Foolio Jones. Should be like Charles, quote-unquote, Julio Foolio Jones, but anyway. Throughout the proceedings, Judge Sisco has exhibited overt hostility toward the defense, repeatedly interrupting counsel, refusing sidebars, and visibly prompting the prosecution during witness examinations. Now that we didn't see. I don't necessarily hear the repeated interruptions because again, we watched it. That was our exercise yesterday. We went through about 7 or 8 snippets. We watched full testimony of Robert Howard, full testimony of Alicia Andrews. I personally didn't see her being interrupted. If anything, I saw the defense interrupting her, and even to the point where she's like, excuse me, this is not the time I'm talking, So if anything, it was the defense interrupting her. But anyway, don't know about refusing sidebars. Again, we didn't watch the whole trial, so I can't talk to that. Nor can I really talk about interrupting counsel because, like I said, from what I saw, it was the other way around, but we didn't watch the whole trial, so can't speak to it. Visibly prompting prosecution during witness examinations. Didn't see that either, but again, we didn't watch the whole trial, so we'll just leave it at that. Moreover, her public assurances to the jury that it would receive the case for deliberation by a specific date demonstrate a predetermined timetable inconsistent with judicial neutrality. Now that I will agree with, because we saw that in Alicia's trial. We did actually watch that part, and then I also we saw that in the other 4 their trial. So I did see that, and I that rubbed me the wrong way too, in the way of she's like, this trial will be over by Friday. This trial will be over by Friday. You will get this, and then for the penalty phase, she said, I got to look at my notes again, but it was something to the effect of, yeah, this, you're going to start to deliberate on Friday and it's going to be over. It's going to be over on Friday. And oh, no. You know what she said? She said, it's my experience that penalty phase takes less time than the guilt phase. And to me, I remember when she said that, and I questioned that. I was like, that sat with me wrong. And then also when she was talking about during the guilt phase, you'll get this trial will be done by Friday, and it was Mother's Day, I think, on Sunday, and she's like, you will be sequestered, but we're not going to hold you. You'll be released, to go home for Mother's Day. I think she should have said, you can deliberate for as long as you want. There's no time limit. Deliberate as long as you want. Instead of saying, penalty phase takes less time than guilt phase. That didn't sit right with me. All right. Good job, Aaron. Aaron was able to locate a feed for us. So here we go.
Were made, and those choices had deadly consequences. Thank you for allowing me to speak on behalf of my son.
All right. Let's just back up a little bit. All right. Here we go.
Participate. Whether she pulled the trigger or not, my son would still be alive today had people not participated in carrying out this plan. A mother lives with instinct and intuition, and mine tells me that this was not ignorance. This was participation. It was calculated. They planned it. On my way driving here, every second, every minute, every hour, they could have changed their mind. They could have turned around. But yet and still, they carried on the plan to hunt my son down like a deer in the woods, like they were hunting. This was loyalty to violence over humanity. My son was treated like his life did not matter. He was ambushed and robbed of the chance to grow older, become a father one day, continue his career, and simply live. Every birthday, holiday, and family gathering is now filled with grief. I replay the memories of my son constantly. I think about his laugh, his voice, and the moments we will never get back. The trauma from this loss follows me every single day. No sentence will ever bring Charles right to me, but accountability matters. Alicia's family can see her. They can talk to her. She can see her child, but I can't see my child. I have to go to visit him in a wall at the cemetery. I ask this court to remember that behind every headline is a real family suffering permanent damage. My son's life mattered. He was not disposable. The emotional devastation caused by this murder reaches far beyond the courtroom and will affect my life forever. I respectfully ask the court to impose a sentence that reflects the seriousness of the role Alicia Andrews played in the events that led to my son's death, because she knowingly knew what was going on. Choices were made, and those choices had deadly consequences. Thank you for allowing me to speak on behalf of my son, Charles Jones.
Do you have any questions of the witness?
No, Your Honor.
Does the defense have any questions?
No, Judge.
All right, thank you. You may step down.
Judge, that's the only witness that we're
Okay.
going to call.
All right, and the defense not intending to call any witnesses, is that correct?
That's correct.
All right, so I'll let the state present argument with respect to the recommendation for sentencing.
Yes, Your Honor. We did also receive the defense motion to take judicial notice where they listed, I think, 8 different cases.
I saw that. It was filed in the court file just for the record, May 8th of 2026.
And Judge, I noticed that they were either manslaughter cases or leaving the scene of death. However, upon reviewing them, we did note that they are clearly distinguishable from the facts of this case. The majority of them were negotiated pleas and had reasons for a downward departure. Some of them were, that was the only reason, was a negotiated plea. Others were mental disorder or unsophisticated manner, isolated incident. And Judge, we would argue that those are completely separate and distinct from the facts that you have in front of you, Judge. This case was originally filed as a murder too. The jury has spoken, and we respect the jury's verdict. They have found her guilty of a manslaughter, but still the facts of this case are egregious. We are talking about a person who was hunted down. The people that actually pulled the trigger, they're going to be sentenced later and held responsible for that. But what we're asking the court to do is to give this defendant accountability for her participation in this crime. And we are going to be asking for, she scores at bottom of the guidelines, 9 years prison, Florida State Prison, and we're going to be asking for a 15-year prison sentence based on the serious nature of this particular case and the way that it was conducted and carried out, and also based on the mother of the victim in this case also wanting a serious sentence reflective of the facts and nature of this particular case, Judge.
All right, thank you. Defense?
Yes, thank you, Judge. So we are asking the court not to give a 15-year sentence in this case. We're asking the court actually to depart downward under 921.0026, Section 2B. Judge, in that section specifically states the defendant was an accomplice to the offense and was a relatively minor participant in the criminal conduct. We believe that applies here. We also believe there are some other subsections that apply, but that one in particular, just based off of the jury's verdict in this case, where there are 4 other co-defendants who were convicted of much higher offenses that were actually facing the death penalty. The state recognizes that there was a difference between those co-defendants and Ms. Andrews, and the fact that they were convicted and are likely to be sentenced or will be sentenced for life in this case. Ms. Andrews' goal, after having read all the transcripts and gone through the trial, is very much minor when compared to those co-defendants in this case. So we're asking the court to go below the guidelines. The reason why I cited or filed a motion to take judicial notice of the 8 cases that I did send over to the court is not because those cases are mirror images of this case. This case is probably a unicorn. Based off of the motions that we filed, right, the motions for new trial and motions for reconsideration, Judge, we obviously believe that the facts of this case don't amount to a manslaughter charge. There was no manslaughter here at all in this case. And that was argued out in the motions, and so I won't go over that. But this case, to find another case that's exactly like it, was not really our intent, but we don't know that that would actually ferret out. But that's not really our intent. The intent of filing a motion to take judicial notice of these 8 cases is to see a range of different sentences for people who've been convicted of either manslaughter or some sort of act that resulted in a death that wasn't an intentional act. And so all of those cases, if we go down the list, right, state of Florida versus Vandal Stedman, that individual received 7 years in the Department of Corrections, followed by 8 years of probation. He scored exactly the same amount of total sentencing points as Ms. Andrews. And in that instance, he made a statement, a spontaneous statement at the scene to officers that he shot him. I shot him, were his words, right? In a situation like that, that's obviously more egregious than any acts that Ms. Andrews is accused of doing or committing. Going down the line, Francisco Vallejo, state of Florida, that was a 2000 case. In that situation, the victim was shot numerous times outside of a trailer park, and the defendant was initially charged with second-degree murder. He pled down to manslaughter. He received a 5-year sentence in the Department of Corrections. He had the same amount of total sentencing points as Alicia Andrews at 176. There are people who had even more total sentencing points. Michelle Diane Young, that's the third case cited there. That individual had 180.2 total sentencing points, received a 5-year sentence in the Department of Corrections, followed by 10 years of probation. And all of these individuals that I list, and I won't go through each one, but it's all attached to the motion to take judicial notice. All of their score sheets, all of their arrest affidavits, the judgment and sentences. All of these individuals, none of them got 15-year sentences. The state is asking for the max on someone who's never been convicted of anything before in her life. This is her first offense, and for reasons that are cited in the motions, the replies, Ms. Andrews will be taking an appeal on the case, on the jury decision, and the rulings that were made in the trial, right? And so she does intend to have a new trial if the appellate court grants it. So she's not testifying here today, and no one else, no witnesses are testifying here today for that reason. So we're asking the court not to take into account the fact that Ms. Andrews is not on the stand testifying, or that her parents are not on the stand testifying on her behalf. And we're asking the court to depart below the guidelines to give her a credit time cert, and followed by 5 years of probation.
Anything else from either side before I impose sentence?
No, Your Honor.
No, Judge.
All right. So the court, having obviously reviewed the trial transcripts, the court file, all the evidence in this case, the pre-sentence investigation report, the argument of counsel, it's the Florida State Prison. You have 30 days to appeal the judgment and sentence. If you cannot afford an attorney, one will be appointed to represent you. You all let me know when you're ready on Casal, please. Okay, thank you.
Well, boom. There you have it. Was not expecting that. I thought this was for a new trial. She literally just got sentenced to 15 years. So, just like that. Well, snap. I guess I can end the poll. I'll end the poll. Judge like, yep, nope. I'll end the poll. Will she get a new trial? I guess not. I guess not. If you blink, it's over. So there you go. She's sentenced to 15 years. She got sentenced to 15 years. You blink and it's over. Yeah, that happened so fast. I want to see that again.
If you cannot afford,
Let's
watch that
from
again.
either side before I impose sentence.
No, Your Honor.
No, Judge.
All right. So the court, having obviously reviewed the trial transcripts, the court file, all the evidence in this case, the pre-sentence investigation report, the argument of counsel, it's the judgment sentence in order of this court to adjudicate the defendant guilty, sentence her to 15 years in the Florida State Prison. You have 30 days to appeal.
sentenced her to 15 years in the Florida State Prison, 30 days to appeal. So there you go.
The argument. All right, so the court, having obviously reviewed the trial transcripts, the court file, all the evidence in this case, the pre-sentence investigation report, the argument of counsel, it's the judgment sentence in order of this court to adjudicate the defendant guilty, sentence her to 15 years in the Florida State Prison. You have 30 days to appeal.
I don't know how much more clear it can get than that. I don't know how much more clear it can get. It's 15. So boom.
The judgment and sentence. Done. If you cannot afford an attorney, one will be appointed to represent you. You all let me know when you're ready on Casal, please. Okay, thank you.
And off you pop. Jesus. Wow, that was fast. Yeah, snap for sure. Judge was not messing around. All right, so 15 years. Off she goes. I don't know if she gets, like, when she's allowed probation. Let's see. Like, after 75%, let's see. When are inmates eligible for parole in Florida after a 15-year sentence? Let's see if we can find out. All right. In Florida, parole is largely abolished. An inmate is only eligible after a 15-year sentence if their crime was committed before. Yeah, that doesn't work. They must serve at least 85% of their total sentence. So 85% maybe, if I'm reading this correctly. An inmate, okay, here's the Florida statute. Let's check this out. So will she get a new trial? No, I think I can change that to no, she did not get a new trial. All right. Let's see if I can find 15 years. I'm not going to. Okay, an inmate serving a mandatory term of 15 years or more, well, we know that's not true, shall have an initial interview no sooner than 18 months. An inmate serving a mandatory 15 years or more shall have an initial interview no sooner than 18 months prior to the expiration. Oh, prior to the expiration. And judge would have said, Florida PI Sam says, judge would have said if she was eligible for probation after a certain amount of time. Right? But here's the Florida statute says, an inmate serving a mandatory term of 15 years or more shall have an initial interview no sooner than 18 months, so that's a year and a half, prior to the expiration of the mandatory minimum portion. So I don't know if after she serves 15 years and then she's out. Sounds like it. Sounds like she's going to serve 15 years and that's it. So, all right. So there you have it. I still want to play. These things. I want to get these. I want to get these on the record. Let me see if I can find. Where are these? All right, we're going to play some stuff that I'm pretty sure you guys have not seen before. Hold on a sec. All right, so because that was so fast, and I want to play some other stuff for you guys. I want to get this into our library. So if you guys, let's see here. hang on.
I think, with the thumb drive. So here's a copy of this.
Yep.
Yeah, okay. Is that possible to do with the laptop?
Just hold your laptop and then you'll click the external here and then it'll come on the TV.
Whatever's displayed on the laptop will come up there. And then, does he have a remote, or should he just use the button on the laptop?
Could be the button on the laptop.
All right, so I'm going to show you some things that I hope you guys like. So these are, this is the Rashad bond hearing. So this is, I'm going to show you a couple things that we haven't. This is from September 8th. September 8th of 2024. So let's check this stuff out.
So can you send me what classes? This is the next video. That's truth 18? This is 2. Okay. Listen to this. Oh, this is when they get home.
Represented him, but I know they conflicted off the other co-defendants, and then I saw, I think, that the Public Defender's Office moved to withdraw because I think there's now private counsel for the individual they were representing. So we can't go forward with the hearing until Mr. Murphy has representation. So I know regional counsel is already representing one of the other co-defendants, correct?
They are.
So I'm assuming they would have a conflict representing Mr. Murphy as well?
Judge, I'm not sure about that because I think some of the attorneys contract with them. So they may be able to lull off as far as conflict goes. I'm not sure what their response would be on that.
So, but we need to get, I guess, start with regional counsel first. And I did have because when I was looking at this, I realized we might have an issue. And my JA did reach out in case regional counsel has a conflict. Attorney Nick Sonardi is available to take this appointment. I don't know if he can be here this morning to conduct this pretrial detention hearing is where we're at.
Yeah.
So I think what I'm going to do is have my JA get on the phone right now with regional counsel, because I think that would be the first stop, correct?
Yes, Your Honor.
To see if they have a conflict.
Yeah.
And remind me from regional counsel who's representing one of the co-defendants.
It is a Wallace attorney.
Justin Petritas.
That is Justin Petritas.
Yes.
Okay. Okay, so let me start with regional counsel. So if you've got witnesses, I think someone's here on the Zoom waiting to get in, or you all have any
That
Zoom?
may be next of kin, Your Honor.
Okay.
We have 2 witnesses here, 2 law enforcement witnesses.
Pedro Luis Cabo.
I do not recognize that person. That may be someone related to the defendant. Not sure. Yeah, please.
Thank you.
Okay.
Pedro Luis something.
Okay. Good morning. We are just attempting to determine who's going to be representing Mr. Murphy, the defendant. All right, so just stand by. Okay. All right, so let me go call regional counsel, see if I can get an answer, and we may have to push this off to the afternoon or potentially sometime later this week, depending on who's going to be representing Mr. Murphy. And just to clarify, you are in fact Rashad Murphy, correct?
Yes, ma'am.
Okay. All right, Mr. Murphy. And do you know, did the Public Defender's Office represent you at first appearance?
I had told him my attorney was being finalized, and my attorney told me that he's just getting everything situated, but I told him he could represent me if he, I don't know.
Are you attempting to hire private counsel?
My family's trying to handle everything, my wife and my auntie.
Okay. Okay, but as of yet, they're not signed on to represent you.
No, ma'am.
Okay.
That's why I had told him that he's being finalized and he said to get everything situated.
Okay, so you're set today for a pretrial detention hearing, and that would be a hearing for me to determine whether or not you would be entitled to bond. And so the problem is you obviously have to have a lawyer represent you. And so at this point, I've got to figure out, for the immediate purposes, who's going to represent you, because we can't have a hearing if you're not represented. All right? So I'm going to first start with regional counsel. The public defender's office withdrew as to all of the co-defendants except one because they had a conflict. So I don't believe they'll be able to represent you, which means the next step would be to go to regional counsel. So I'm going to contact regional counsel now and see if we can get someone down here just to let me know if they're going to be able to accept the appointment or not. If regional counsel cannot accept the appointment, then I would appoint attorney Nick Sonardi off of the conflict list. However, that doesn't negate your right to hire your own counsel. So if you and your family are able to get the money together to hire a private attorney, great, then we can proceed forward that way. But for the immediate purposes, you have to have counsel. Okay? All right, let me go make a phone call. I'll be back. All right? Okay. I'm not going to be able to represent Mr. Murphy. We're attempting to reach Mr. Sonardi to see when he can get down here. I would be surprised if he said he was ready to do a pretrial detention hearing today, but I mean, he could, I just don't know. So we're just waiting to hear back from him. So you guys can do whatever you wish to do as far as your witnesses go. I mean, if they can be on standby to come back, or if you want them just to stick around, it really, it's up to you.
Okay. Well, we have one witness from Jacksonville who's here.
Okay.
Law enforcement, and then a DPD officer.
Okay. Well, if we have to, I can do it later this afternoon. You know, let me see what I've got. I can do it first thing.
Later today?
Yes, sir.
Okay. Yeah. We're fine with later today.
Later today.
I'm sure.
No, I hear you. That's fine. So I just need to make sure Mr. Sonardi is available and is ready to go. So,
Good enough.
okay. So as soon as we hear back from him, I'll let you guys know.
Thank you.
Yes, sir.
304-5046. Anna, your favorite.
AV Stat Media, all 4K video equipment with 35mm.
All right, so that is that was Rashad's bond hearing from September. Now I want to check out. Here's another clip that I want to show you guys. All right, this is a hearing for Rashad, Davion, Isaiah, and Sean. And this is from September 18th. All right, so this is a status review hearing. So this is a status review hearing. Kind of interesting to see Rashad with glasses. Like, we didn't see him with glasses at all throughout the entire trial. And Rashad has glasses. Yeah, Julio, I know, right? Well, that's the feed that we're using. I can put this back up now. Yeah, Isaiah is pretty it's pretty thin. Well, that's why. Yeah, Sean and Isaiah were quote unquote the thinner of the four, and then that's why they they were body shaming Davion throughout the trial. They're like a heavier one. Excuse me. Now, let me fast forward a little bit through here, if I can. Can I fast forward? See, now they're in red. We thought that red meant that you're under 18. Oh, and there's Alicia. Yeah, they're all in red. It means a few things in Hillsborough County. Okay. Oh, under 21. Okay. Under 21. All right. Thanks, Aaron. So red is under 21, not 18. And high profile. So it's high profile and under 21. And Sean's there. Red and orange, no brown and green. They have just red and orange. I don't know why I know they're all kind of grinning, right? Well, Lance, yeah, she thought she would get a new trial. Well, they tried. If you were in that position, you'd want your attorneys to try as well, I guess. I don't know. Kaylee, off to a meeting. See you around lunch. Sounds good. Yeah, not so funny now. Jane, Ray, they'd be smiling and laughing, right? Yeah, they're all like, yeah. Nobody's like taking it seriously. It's like Isaiah shivering. Let me fast forward a little bit here. And Sean talking to his counsel. We did not see her. Let me see if we can get to actual. Does the judge actually come in and talk? When does this start? Here.
Okay.
All right. Hey, Crunchy Frog, good to see you.
Pardon me?
Good morning, Your Honor. How are you?
Good morning. Good.
Hi, my name is Lenina Hurdle. I am here on behalf of Alicia Andrews as her attorney.
Okay. And tell me, how do you spell your last name again?
Hurdle.
Hurdle. Pronounced Hurdle?
Yes, ma'am.
Okay, very good.
Thank you.
All right, and your client is present with you in court?
Yes, she is.
Good morning, Your Honor. Brian Gonzalez here on behalf of Mr. Murphy, Rashad Murphy.
Okay.
Good morning, Your Honor. Michelle Rayner on behalf of Sean Gafford. He is present in the box, Your Honor.
Okay.
Good morning, Justin Patrice on behalf of Isaiah Chance, who's also present in the box.
Okay, very good.
Michelle Doherty on behalf of the state, and Anna Ismail.
Okay, very good. All right, so all defendants are present as well as their counsel and the state. So I believe everyone has waived speedy trial, is that correct?
Judge, with the exception of Miss Andrews, I think that is the only one who we have yet to get a waiver from.
Okay. All right, Ms. Hurdle?
Yes, Your Honor. At this time, we will not be waiving speedy. We will be invoking a right for a speedy trial.
Okay, so that's definitely going to speed things up, everybody.
Judge, we've calculated, I think, January 18th of 2025 is when it was on.
Okay. So at this point, and I did look, because I know Ms. Rayner, and I do apologize, I believe you're in the Florida legislature, correct?
I am, Your Honor, and I'm actually, well, not even constitutionally, I'm not even available pursuant to the Florida statute 11.11. And so that just maybe puts me in a position where I may have to move to sever because I'm constitutionally unavailable.
Well, let's see. The legislature is in session for 2025, March 4th through May 2nd.
But I'm in committee weeks, though, as well. And so the statute contemplates also committee weeks as well.
And so it looks like, and I don't know, because I looked this up, I don't know, I'm sorry, you in the House or Senate?
I'm in the House, Your Honor.
Okay, and one has January 13th through the 17th, and the other has January 21 through 24. So which one is yours?
So those runs, so we will be in committee week together at the same time. So the January, and I just wrote these dates down, so committee weeks. Apologize, Your Honor.
Okay.
I'm pulling them up now. So the week of January 13th, the week of January 21st, the week of February 3rd, and the week of February 17th, I will be in committee those weeks. Also, the week of December 2nd, I will be in committee. Legislative session starts March 4th. Once again, I will be unavailable. I think based on the representation by Ms. Hurdle and our client, Ms. Certainly both in right now to waive that, I just will have to have a hearing on.
Okay.
If it's reasonable to sever.
So, then we'd have to get this to trial before January 13th, right?
Yes.
Okay. So, the week of January 6th?
Your Honor, may I be heard?
Yes.
Your Honor, Brian Gonzalez on behalf of Rashad Murphy. Judge, I'm not speaking for any other counsel, certainly for myself on behalf of Mr. Murphy. As the court knows, he's charged with first-degree murder. We have not received a notice yet, but we potentially contemplate that there may be a notice filed by the state seeking death. As the court is aware, this is a 5-defendant first-degree murder that encompasses dual jurisdictions, both Jacksonville and Tampa. Although I haven't looked at the state's discovery notice, because I just received it a day or two ago, inclusive of the in excess of 300-page police report, as well as what I anticipate to be dozens of listed witnesses, I anticipate, as it relates to first phase, having to engage multiple experts experts inclusive of cell phone and social media.
Well, listen, and I don't mean to cut you off, but if that's accurate, that the state is considering the death penalty against your client, is that accurate, first of all?
Judge, it is accurate. A final decision has not been made. It is going to be reviewed within the next 2 weeks, Judge.
Okay. So
It's
that
not
does,
just his client, but there are others as well.
Inclusive of my client as well, Your Honor. And I would also adopt most of Mr. Gonzalez's argument, but I would defer to him.
and you guys can remain seated when you're talking to me, unless you need to stand up to see me. That's the only reason why. Okay. Okay. So, and then, Mr. Petratus, what is your position on being ready to go to trial by January 6th?
I agree, Judge. I don't know how it would be possible on a case of this magnitude to be ready by January with all these witnesses.
Here's the other thing.
I see you guys are asking some questions. Yeah, Alicia was sentenced. If you missed it, rewind about a half an hour. If you blink, it happens so quickly. If you hear my voice right now, rewind a half an hour. She was sentenced to 15 years. No new trial. Judge Fernandez sentenced her to 15 years. If you want to rewatch it, go back about half an hour. Again, if you hear my voice and you want to see that, it literally was about 28 minutes ago, 28 minutes ago from this point right here. So what we're doing is, instead of just ending the stream after half an hour, we're going to go ahead and we're going to show things that I've never seen before. So we want to put this on our channel in our content, if you will. So you can hang out and watch with us if you want, but Alicia was sentenced to 15 years.
This is the deal. Now, I'm not going to give you all, if one defendant decides they don't want to waive speedy trial, that's fine. That's absolutely right. However, we're not going to have witnesses being deposed and redeposed and brought back on anyone else's schedule. So discovery will have to be expedited, and you guys are just going to have to be ready to go. So that's just the way it is. Okay? And then if something occurs and you've already deposed a witness and a new issue has arisen and you want to go back and talk to the witness about something different that wasn't already covered, then great, we can talk about it. Maybe the state would stipulate. But that is going to put a time crunch on discovery. Okay, Ms. Hurdle?
Yes, Your Honor. Also, I will be probably speaking with the other defense counsel on this as it pertains to our position with wanting to move forward with the segments as well. So that may be coming essentially.
Judge, there's not a thing that Ms. Hurdle could tell me in any type of conversation that would put me in a position to acquiesce to a speedy trial. In fact, having done this for an extremely long period of time, I would not risk Mr. Murphy's life on trying this case in a speedy trial capacity. I would withdraw before that.
No, and Mr. Gonzalez, listen, if the state seeks death, it's a whole different ballgame. Okay, so I'm not at all would try to force you into trial under those circumstances. So this is the first time I've heard that the death penalty was even being considered for any of these defendants.
And Your Honor, with all due respect, all of our clients have different positions in this case, as we know there's several different co-defendants.
Sure.
But all of us are speaking on behalf of our own clients' interests and
Right.
based on their
But
position in the case.
what I'm trying to stress to you all is because one of the defendants, Ms. Andrews, because she's not waiving speedy trial, that means if there's going to be discovery, it's got to get going immediately. And so, and what I'm trying to stress is that all of the other co-defendants' attorneys are going to be noticed when these depositions are occurring, and I'm not going to allow several bites at the apple for these witnesses. So,
And Your Honor, and understanding that, but I haven't even received the discovery. I know the state emailed out the first portion, I believe, which is a police report yesterday of 300 pages. We just received that before we yesterday, I went to my old law firm. So I understand the court's position of us being ready, but we haven't even had the opportunity to review what the state has given, what the state has initially given us. Obviously, there's going to be copious discovery, and I do echo Mr. Gonzalez's point. You know, whether the state is seeking death or whether it is life, my client's life is on the line, and I'm not. I would literally be doing him a disservice. I mean, to try this within by January 13th.
Wait, guys, I guess I'm not making myself clear here, okay? I'm not gonna make the other 3 co-defendants go to trial in January. What I am saying is that I'm assuming, Ms. Hurdle, are you gonna participate in discovery?
Absolutely, Your Honor.
Okay, so I'm assuming there will be discovery depositions that you're gonna schedule?
Absolutely, Your Honor.
Okay, and so then those dates need to be coordinated with the other 3 co-counsel. That's what I'm saying to you, apparently not clearly enough. What I'm saying is you guys are going to have, the other 3, Ms. Rayner, Mr. Petratus, Mr. Gonzalez, you all are going to have to be ready to go on starting to participate in discovery immediately. That's what I'm saying. Okay?
Judge, one more thing for the record.
Sure.
If you don't mind. I tried the State versus Devon Speed in front of Judge Kaiser starting October 28th or 29th, whatever that Monday is, for a week and a half. I'm going to be in preparation for that trial over the next 3 or 4 weeks, so I want, obviously, the court to know that my availability for depositions, and certainly I can try my best to be available when I can. I don't even know that I can be prepared to take a deposition without having read a police report. So to the extent that I can make myself available, I will, but I can certainly suggest to the court that I'm not willing to have other counsel depose critical witnesses in this case without my availability, and then have to rely on that questioning without the opportunity to do it myself. So again, for the record, I just want to be clear that if it comes to the point where participation in discovery for me over the next 60 days or 45 days is not capable, I probably will be asking the court to allow me to withdraw, because I am not going to take that ultimate responsibility as it relates to Mr. Murphy.
So, you all can start taking depositions in November and December, correct? Can you not be ready in November and December to at least start taking depositions?
Potentially in the middle of November, Judge, I would think, to the best of my ability. Again, I'd have to advise the court if I didn't think I was really ready to begin those depositions.
Of course. But you guys know who, for example, the lead detective, there are certain witnesses that you know are going to have really the bulk of the discoverable evidence. And I would encourage the state to begin coordinating dates in November or December for these depositions to start occurring. So, and what I'm going to ask when we're concluded here today is that you all stay behind, you start looking at your calendars, and you start setting aside dates in November and December. Just close them out for discovery depositions, all right? And of course, if anything arises, if there's any issue, if the state does intend to seek the death penalty, I would never, ever, for the integrity of the fairness to the defendants, the state, I would never, ever put an attorney in a position to where they couldn't be prepared or effective. I would never do that. But we do have a situation where we've got one defendant who's not waiving speedy trial, the other 3 have. And as I've indicated, to the extent we can, I want to avoid duplicate discovery depositions occurring. So it seems like November and December, there should be wiggle room for you all to be able just to start setting dates aside for depositions. By then, you should have all of the reports. If you don't have all of the reports by November 1st, then I need to hear about that before then. And I'll take action to make sure that you do. So, yes.
Your Honor, if I may, yes. When I had a lengthy conversation with the state yesterday, they did advise me that they pretty much think they will have everything within the next week or 2.
Is that correct?
Judge, not everything, because there are reports from outside agencies, but I've talked to the main case detective. There is a lot of evidence that is going to be digitally downloaded that he is downloading now that may take a day or two to download all of it, which will be brought over to me, and I can make sure and ensure that once I get it downloaded that we're going to figure out a way how to get it sent to all defense counsel. I do know that all of the report that I have thus far has already gone to them, with the exception of Ms. Rayner, because I believe I had the wrong email address, and my secretary will certainly get that to her today. When I was going through the police report, I noticed that there are still supplements that are outstanding, so I'm definitely reaching out to the detectives to try to get all of that in, but I also know that there are outside agencies, including Jacksonville, Georgia law enforcement authorities, that I have to get police reports for that as well. So whether or not that will be within the next 2 weeks, I'm certainly going to work my hardest to do that, but I have to wait for some of these reports to be completed.
Okay, so completed or provided to you?
Completed and provided to me, Judge.
Okay, so I want whatever agency has outstanding reports, I need you to contact them and tell them they've got 10 days to get them submitted to you. So that would be, all outstanding reports have to be submitted by, actually you've got close of business September 27th. Okay? And if you're having any trouble with any other agency or any other jurisdiction, you just need to tell me, and then
yes, Judge,
I'll address it myself. Okay? So all outstanding reports, other than the exclusion would be if FDLE is still conducting testing of any evidence. If it's just, you just need to let the defense counsel know that I don't have this FDLE report or whatever it may be, because they're still testing. But all outstanding reports need to be, you need to have them by the 27th, and then they need to be produced to the defense by October 1st. Okay? Okay, so let's deal with Ms. Andrews then. So State and Ms. Hurdle, January 6th for trial. Okay?
Yes, Your Honor.
And we will set a pretrial conference, which will be a status for everybody, but it will be a pretrial conference. December the 19th at 10 a.m.
Your Honor?
Yep.
If I may, I just wanted to notate or remind the court, because obviously I'm new here, this is my first appearance. My client actually is pregnant, so that's another reason why there's certain decisions.
When is she due?
She's due February 15th, 16th.
Okay.
So just for the record. Thank you.
Noted. Okay, so then let's look at our calendars for a trial date for the remaining defendants, all right? Because the biggest issue in a case like this with 4 separate defense attorneys are the schedules of the defense attorneys and the state. So Ms. Rayner's out of pocket most of the spring, correct?
Correct.
For her legislative commitments. So we're looking at late 25, early 26.
Judge, and I would prefer October of 2025, if defense counsel could be ready by then.
Judge Brian Gonzalez on behalf of Mr. Murphy. Judge, I have State versus Zavante Sampson, which is a 2021 case, and it is just going to trial division now from Division I, and the court just got all of our respective dates. It's a 5-defendant case, and it appears that September of 2025 is when that case is going to be set. Although there may be severances, there'll be at least 3, if not 4 of those defendants that will be tried together. I also have State versus Josue Claval, which is a death penalty case. It is also a 2022 case, and I anticipate that being tried in mid to late 2025.
Well, has that judge set a trial date yet?
That's not set. That's not set. That's what the calendar lawyers have provided to the court.
I understand.
I would request early 2026.
Judge,
Well, because then I don't want it, because then this is the problem that we're going to run into. We're going to run into the same legislative conflict for Ms. Rayner. So it's got to be 2025 in the fall, October, November, December.
Your Honor, if we were going to try this in 2025, it would be preferable for me either in November or December. I will be in committee weeks, and I know that legislative session for 2026 goes from January to about March, in the very beginning of March. So if we were to go into 2026, I could do mid-March or April 2026. I don't have the committee dates for 2025.
Well, we can assume it's going to be it's similar this year, correct?
So the committee dates in 2025, and
it precedes the legislative session, correct?
So the committee dates usually in 2025 are October. There's one in October, a sprinkling in November, and the rest in December, and then we go into legislative session probably that second week of January, and then we are done the first week of March 2026 because it's an off-cycle election year. I don't have those dates, but those are kind of what it historically has been.
Right. So, hence my comment that the spring is normally no good for Ms. Rayner. So I guess I have a question for you. Just if the state seeks the death penalty against one or more defendants, would everyone remaining be tried together, or would the death penalty defendants have to be severed out?
Judge, I'm not sure about the answer to that question. I'd have to research that. If the death penalty wasn't on the table, I knew that our strategy was to try them all together. We didn't believe that there was any motion to sever. I have not looked at, and I'll have to talk to Mr. Harmon to discuss whether or not that position will change if we file notice on some of the defendants.
Okay, so here's what we're going to do. We're going to pick a trial date, late 2025, for any defendants who've waived speedy trial where the state is not seeking the death penalty. Because honestly, my gut instinct is you can't try them together. That's my gut. I could be wrong, but that's my gut instinct. So we're going to pick a date, and we're also going to pick a date in 2026 for any defendants where the state is seeking the death penalty. Okay? So I'm going to preliminarily set aside 2 weeks. December. You guys want to start the December 1st, the Monday after Thanksgiving?
Fine, Your Honor.
2025?
Yes.
Yeah, that's fine.
Not 2026. We're not going to go that far into 2026. It'll be in the same soup. Okay. So, and I would anticipate.
Sorry, what was the date you were starting?
December 1st.
December 1st.
2025. And assuming we have 3 co-defendants where the state is not seeking death, we should be able to get this case tried in 2 weeks, including jury selection, right?
Yes, Judge.
Yes. Okay. So that's our prospective trial date. Please block out your calendars with any other judges for those dates. Then, looking at 2026, any defendants who are facing the death penalty. Remind me, let's see here. The legislative session is normally done by May, early May?
So that year, Your Honor, it will be done by March, because that's the earlier.
I see, okay.
That's the earlier.
So we're looking at April 2026?
Yes, Your Honor.
Let me look up, someone look up on your phone real quick, see when Easter is, 2026.
April 5th.
April 5th, okay. Thank you. So then we would start April 6th, 2026. 3 weeks I will block off, so that would be through April the 24th.
Judge, can we actually start the 13th?
Fine with me.
That way we have like a week we don't have to prepare during Easter.
Sure.
No objection, Your Honor.
All right. any defendants where the state is seeking the death penalty. Trial will begin April the 13th, 2026 through May the 1st, 2026. All right? So let's set another status, see where we are. And I will have a proposed scheduling order for you guys. The state, you said you should make up your determination regarding the death penalty in 2 weeks?
Judge, yes.
Okay. So then depending on what the state decides, then I'm going to do a scheduling order as far as the filing of motions, the disclosure of any witnesses, just to keep us organized, okay? But that way we'll know which way the wind is blowing and when people are actually going to go to trial. All right? Okay. So, let's set another status.
Judge, it may be 3 weeks because we may be meeting on the 10th, so I just wanted to.
Of October?
Yes.
Okay. All right. So, yep.
Excuse me. Yes, I have already filed a few motions back on the 27th of August, so I'm not sure whether you were seeking to, at the same time as the status hearing, to hear those, or if you would like me to.
What type of motions are they?
A motion for statement of the particulars and also to reduce the charges.
Okay. Are they don't sound evidentiary in nature?
No.
Okay.
Not at the moment, but I was just trying to see if you wanted all the motions heard at the same time as the status hearings or at separate times.
Have you seen the motions yet?
Judge, I have not seen them, so I'll check with my legal assistant to see. I'm sure, when were they set?
August 27th.
Okay, Judge, we did get them.
Okay.
I'll look at them.
Okay, very good. Okay, so I'm going to set another status for October the 17th at 9 a.m. Is everyone available?
I'm sorry, Your Honor, I was distracted. October
17th, just a status, see where we are.
I am, I'm actually here.
Judge, were the states available?
I'm available here.
Okay.
Attorney Michelle Sisco is available.
Yes, Your Honor.
Okay, very good. So we'll know better who's going to trial when. And then Ms. Hurdle, when we come back on that date, any and all, I'll set a motion hearing date for you separately for your client if there's any outstanding motions. So, but just so you know, because you're not waiving speedy trial, any outstanding motions must be filed by Defendant Andrews no later than October 31st, 2024. Okay? That's your deadline to get your motions filed.
October 31st?
Yep.
Yes, Your Honor.
Okay. Okay, very good. All right. Anything else?
No, Your Honor.
Okay. Oh, you guys need to stay. Your clients will be excused. You all need to stay and start blocking out deposition time in November and December. Okay? Just start blocking it out. All right? See what you can get done. Okay? Okay. After you talk to your clients, then you guys need to confer. And when we come back, when I see you for the next status, I want to hear what your dates are that you've agreed to begin your depositions. Okay?
All right. So that was from September. I don't think there's anything more in there. Yeah, so that was from September. September of 2024. So they were arrested in July. I forget the exact dates right now, but happened in the end of June. I think they were arrested like 3 to 4 weeks afterwards. So, all right, next up is going to be, we're not sure when this date is, but this is a hearing for Sean, Alicia, and Isaiah. So let's check this out. And if you are coming in late and you want to see the sentencing, it already happened. It happened so quickly. We thought it was going to be take a couple, maybe an hour or two or something. I don't know. It was really weird how quickly it happened. So if you want to rewind it, we have it. Just give me a second. Let me cue this up. It's probably about 45 minutes ago now. Let me just cue this up and I'll tell you how far back you need to rewind. All right. So I'm not sure when this is from. We're not sure what date this is from. All right, so if you want to actually see her sentencing, it happened, if you're hearing my voice right now, it happened about 50 minutes ago. 55 minutes? Yeah, 50 to 55 minutes ago. So if you want to rewind and watch it, it was about 50 to 55 minutes ago. So that's when the actual sentencing happened. So yeah, no new trial. She got 15. July 29th, Jimmy was, yeah, sounds about right. Yeah, I know it was about a month, about 4 or 5 weeks later. That sounds about right. And then Rashad was a little bit after that, and then Davion, of course, was in January. Okay. Oh, and Alicia had, she was due February 16th. So I didn't know she was pregnant. See, I didn't see any of this pretrial stuff here. So this is, for me, this is good. This is good to watch because now we're finding out that she knew she was pregnant at the time of the incident. Can you imagine that? You go, you do this thing and knowing that you're pregnant, but that's what happened. All right, so let's, I'm sure there's no talking here for a while. So there's Isaiah. Doesn't really seem to be smiling. There's Alicia. Yeah. Sorry. Fine when the judge comes in. Oh, wait, weren't we wondering what's on her neck? Princess? Remember we were trying to figure out what was on her neck yesterday? Yeah, it says princess. We were trying to, at least I was trying to figure out, and maybe Good Vibes you were trying to figure out. We were trying to figure out what was on her neck. It says princess. Yep, princess. All right. So Isaiah. And you guys have a baby coming. Wow, there's a lot of just trying to find out when the judge comes in. There's Sean. I'm thinking a judge comes in at some point here. There she is. All right, judge on the bench.
All right. Are we anticipating anyone appearing via Zoom? Okay. All right. Very good. All right. I'm going to close that again. All right. And if everyone could identify themselves for the record, starting with the state.
Good morning, Your Honor. Anna Ismer for the state.
Scott Harmon. Nothing said.
Okay, and then is Alicia Andrews present?
Good morning, Maria Junker on behalf of Ms. Andrews. She is present and to my right.
Okay, very good. Isaiah Chance.
Good morning, Your Honor. Justin Treatise on behalf of Mr. Chance, who is present.
And I'm sorry, tell me your last name.
Treatise.
Treatise?
Treatise, yes, Your Honor. Sorry.
How do you spell that?
Petredis.
Okay, thank you. All right, and Mr. Chance is where? Okay, good morning. And then Sean Gathright.
Good morning, Your Honor. Attorney Michelle Herrera on behalf of Mr. Gathright. He's present, and then Bob Schroeder.
Okay, and are you Mr. Gathright? Okay, good morning. All right, so we're here for arraignment, and have you all entered written notices already?
Yes, Your Honor.
Okay, very good. So I guess the question is, at this point, do you know if you're waiving speedy trial or not? And you can remain seated. You're fine. You don't have to keep popping up and down.
Yes, Your Honor. Once again, for the record, Attorney Michelle Herrera on behalf of Mr. Gathright, I, at this point, will be waiving speedy trial on behalf of my client.
Okay. And
on behalf of Ms. Andrews, I'll stand just because the podium's in my way. We yet have not made a decision. We would like to review discovery and discuss that with Ms. Andrews prior to making that decision.
Okay. And Mr. Petraeus?
Yes, Your Honor. We will waive speedy trial on behalf of Mr. Chance.
Okay. And then there is a fourth co-defendant that is currently incarcerated up in Duval County. Is that correct?
That's correct, Your Honor.
And what's the status with that defendant?
The defendant, Mr. Murphy, had pending charges in Duval County. Those charges have since resolved, and he should be transported to Hillsborough shortly.
Okay, do we know when?
We do not have an anticipated date of transportation.
Okay, and so has he been arrested on the outstanding, I'm assuming there was an outstanding warrant from Hillsborough?
The most recent outstanding habeas when the indictment was filed was executed.
Okay, so Speedy's running for him?
Yes, Your Honor.
Okay. All right, so have you all, so you don't know yet exactly when he's being transported back?
We do not, Your Honor.
Okay. Do you know what his ex-court date is in Duval County?
As of Friday, the pending charges he had in Duval County had been no filed, so we anticipate that it will be shortly within the next few weeks.
Okay. So, when does Speedy run for those that have not yet waived?
For Ms. Andrews, February 7th, Your Honor.
Okay.
And for Rashad Murphy, it would be, it should be in February as well. We would have to check the date.
But we're looking at
exactly,
February.
But we're also looking at February.
Okay. So, Ms. Dunker, I'll give you a couple weeks to get whatever discovery you can get, but then I need to know whether or not you're waiving speedy.
I understand.
Okay. So, I'm going to set a status for the 3 co-defendants that are here. Are you available September the 5th? You all available?
Yeah, Your Honor, what time?
Whatever time works. You tell me.
The only issue is that, I can probably do like a 9 a.m. because I'm going to be coming from Pinellas County.
Sure.
That works for me.
Mr. Curtis?
I have a 9 o'clock Zoom hearing, unfortunately. Yeah, on the 5th.
How long, what type of hearing is it?
It's just a status check and an injunction paid from Judge Baroni, so I don't anticipate it long, but it should start right at 9, I assume. I think we're the only.
Could we do 9:30 here? 9:30 here?
That's fine.
Okay, so we're going to set the co-defendants that are present here today for status at 9:30, and we will set the arraignment for Mr. Murphy on September the 5th at 9:30, and assume he's going to be here. And if there's, I need you to follow up on that to make sure he's being transported. If you need a writ or anything from me, you need to let me know, but he needs to be here by that date.
Yes, Your Honor.
Okay? All right. Anything further from anybody? Yes.
Yes, Your Honor. I just wanted to let the court, make the court aware, and also the state as well. As the court may know, I am an elected state representative, and so I know that there's going to be chunks in time where I'm constitutionally unavailable.
Sure.
So I'm going to, we don't have some of those dates. We have the session dates, of course, but committee weeks, we don't really have those nailed down. As soon as I get those, I will send a notice of unavailability pursuant to the statute, but I just wanted to kind of make the court aware of that, so and also the parties, so that we know.
Sure, and I appreciate that. And really, the main driver of this is going to be whether or not the two outstanding co-defendants that have not yet waived speedy, whether or not they're going to waive speedy. So that will be the driving force. But we'll know how things are looking by the time I see you guys back here on September the 5th. And hopefully, Ms. Rayner, your schedule is fleshed out a little bit more so you can give me some guidance as far as your availability for trial, should we have to set it before speedy runs.
Thank you.
All right, very good. Anybody else need anything? Okay, very good. See you all then. Thank you.
Excuse me. So, if you missed it, Alicia's sentencing, we thought it would be a hearing for a new trial. She was actually sentenced. So she was actually sentenced. So I put up a poll. Do you think Alicia's sentencing was fair? We have yes, appropriate, no, should have been more time, no, should have been less time. So tell me what you guys think. We put up a new poll. Do you think Alicia's sentencing was fair? And if you don't mind, hit the like button. I appreciate you guys doing that for us. Let us know that you are out there. If you can hear my voice, take a moment and hit the like button. We are going to continue on. Again, here at Trial TV Live, we like to build a library for people that are watching currently, watching down the road, a year from now, 5 years from now, 10 years from now, whatever it may be. So Aaron found these pretrial hearings, and we thought, well, let's go ahead and let's watch them and let's put them into our library so that you have a full picture of what happened. Granted, it's out of order, but we're doing the best we can, and at least we are, we're providing a library for everybody. I'm learning a lot of stuff. I'm learning a lot of information here, so I'm kind of glad we're doing this. And hopefully you guys are, gleaning a lot of new knowledge out of watching this. Again, just painting the full picture. So often we just get a little piece. We watch just the trial. We don't get to watch the pretrial hearings. We don't get to do the deep dives. So here at Trial TV Live, we try to give you as much as we possibly can. If it's out there and we can find it, we're going to show it to you. I know a lot of people like to just come in as a juror, which is fine. I appreciate that as well. I like to watch trials like that too. But I think I more prefer to have the knowledge. That way, when you guys ask questions, we can have intelligent answers for you guys. And accurate. More to the point, it's accurate. It's all about accuracy. All right, so here, this trial is Alicia. Now, this is Alicia only, and this is from December of 2024, December 19th. Yeah, so this is from December 19th. So this is Alicia's hearing from, all right. So this is a two-parter. So this is from December 19 of 2024. Terry Trial Watcher, thanks for the extra coverage. I'm learning a lot. Missed during the trial. Yeah, no problem. Eva says, appreciate the research. Cool. Thank you. Judy, it's all new to me. Thank you for sharing. Our family streams trials. Very cool. Good. Yeah. I mean, I'm glad. I'm glad that you guys are getting some good information out of this as well. All right. Okay, so this is Alicia's hearing. This is a two-parter, and these are both from December 19 of 2024. She should be fairly pregnant at this point, right? Hold on a sec. Yeah. She gave birth in February 2025. So she should be like 8 months.
For a status, so I prefer to call the co-defendants that don't have motions pending today and just. Okay, so what I'm inclined to do, Ms. Andrews has a number of motions pending, and counsel's obviously free to remain in the courtroom and watch or not watch, but you all are here for a status, so I prefer to call the co-defendants that don't have motions pending today and just have our status discussion. So do I have someone here on behalf of Mr. Chance?
Yes, Your Honor. Richard Watts, Regional Counsel.
Okay.
WATTS. Thank you.
Okay, very good. And then I have Mr. Gonzalez is here on behalf of Mr. Murphy, correct?
Yes, ma'am. Good morning.
And then on behalf of Mr. Gathright?
Good morning, Your Honor. Travis Watts.
Okay, very good. Okay, so I guess status-wise, how are we doing? Mr. Gonzalez?
Judge, I'll speak up first. We are getting a voluminous amount of discovery from the state, obviously sooner than we might have otherwise done so because of the speedy trial demand. So I can only speak for myself. I'm still attempting to categorize, go through, separate, review, and determine what I have and what I don't have, based on just the main police report. So I can only report, Judge, that I'm not any closer to setting any kind of motions or any kind of deposition practice, at least at this time, but the state's provided us an enormous amount of discovery today.
Okay, so what do you think would be a realistic deadline for you to at least begin setting your depositions?
90 days.
Okay.
I think that's realistic.
Okay. Mr. Watts?
Concur, Your Honor. Yes.
Okay. Okay, so for the remaining co-defendants, 90 days from today would be on or about March the 20th. So I'm going to give you all a deadline of by 5 p.m. on March 21st. You need a schedule. Okay? The depositions don't need to be taken by March 21st. They need to be noticed and set. But I do want all depositions completed to the extent they can be. You've got till August 1st. Okay? That's a lot of time.
Do our best. Thank you, Your Honor.
You should be able to. I'm quite confident your best will allow you to get depositions completed by August 1st.
I'm not as confident as the court, but certainly we can leave it that way.
I'm an eternal optimist, Mr. Gonzalez.
Thank you, Your Honor.
So, okay, so other than that, is there anything else I need to discuss with the attorneys for the defendants who do not have motions set today?
We'd like to put one issue on the record or discuss one issue.
Sure.
Mr. Mendez is here, and you may recall Mr. Gathright had retained him prior to the state filing the notice of intent to seek death.
Right.
And then he had to withdraw at that point because of the qualifications for the rule. So I was appointed, and Ms. Finkelstein has been appointed as co-counsel. Mr. Gathright has asked if Mr. Mendez can stay on, and he would like to do that. I've not really been able to get any information from JAC on their position because I don't know if they've addressed this, but my thought is he's essentially saving the state money by doing some work, taking a little bit off Ms. Finkelstein and I's plate, and he's not costing the state any more money. We're both on it, we're both death qualified. He'd be essentially third chair. So that is our hope to proceed in that fashion.
But third chair, he'd be paid for funds out of the JAC or funds from Mr.
Gothright's family.
Okay. Yeah, I don't know. I don't know the answer to that question. All I know is, my understanding of the rule is you have to be death qualified to sit on a death penalty case, but I don't know if that applies to an attorney that just wants to sit trial, guilt phase.
I don't think that, because I know that happens often with people who are trying to get death qualified. They would volunteer to be third chair. So as long as he has to qualify, I think he's all right in regards to the rule. He's essentially
Okay.
taking on third chair.
So I tell you what I need you guys to do. Basically, you need to file a motion to that effect. And we don't need to set it for hearing. I'll let you know if we need to set it for hearing. And just lay out exactly what you propose, and then I'll take a look at it, and then I'll see if the state has a response, and then I'll let you know yay or nay.
Sounds good.
Okay? All right.
Judge, I also wanted to put on the record that I am standing in this morning for Danny Hernandez, who is Phase 2 counsel on behalf of Mr. Murphy.
Yes. Okay. All right. Anything further from counsel that does not have a pending motion today? Okay. Very good. You guys are excused. You're welcome to stick around in the audience, but you're excused from the status conference. All right, very good. Miss Andrews is present, Miss Hurdle is present, and counsel, remind me, your new co-counsel?
I am, Judge. Good morning. Jerry McLymont, co-counsel for Alicia Andrews.
How do you spell your last name?
McLymont.
Okay, very good. Thank you. All right, our state and defense ready to proceed. And Miss Hurdle, yes, I acknowledge you already. You all ready to go?
Yes, Your Honor. Can we shift now? Can we put
Yeah, absolutely. Yeah, it's fine. And there is a microphone there, and it does need to stay on all the time. You don't have to worry. The conversations are not being recorded. Those will remain privileged communications, but just for the court reporter's purposes, they do need to remain on.
When you say remain on, so like you can tap it, like hold it down and it'll come off. Don't do that.
Don't do that. No, you don't need to worry. No one's listening, no one's recording. You don't have to worry about any communications that you're having with your client or in any way not remaining privileged. Okay?
Understood.
All right. Okay, so I know the defendant, Ms. Andrews, filed an emergency motion for extension of speedy trial. We can deal with that one first. And state, you've got witnesses here on the motion to suppress.
Judge, we do not. We had a conversation with defense counsel, and we're going to be stipulating to that particular motion, and we're in agreement.
Okay.
And I can put that formally on the record. There is, and I sent a email to both Ms. Hurdle and Mr. McLymont yesterday, basically documenting our conversation, but there is in the videotaped interview of their client, Ms. Andrews, in approximately the 1 hour and 22 minutes into the interview, the defendant invokes her right to an attorney. When she states, "So I'm done, I don't feel comfortable without a lawyer," we agreed to take that out, and anything after that will be redacted from that videotaped interview.
Okay. All right. And so that's defense counsel, your understanding as well, that that's when the point of the interview, 1 hour and 22 minutes in, where your client invokes her right to counsel?
Yes, Judge.
Okay. So I will grant the defendant's motion to suppress pursuant to stipulation by the state, and anything in defendant Andrews' post-Miranda interview that's after the 1 hour and 22 minute timestamp will be suppressed. Okay? All right. So, moving on then, the defendant's motion for extension of speedy trial. Defense filed this motion pursuant to Rule 3.191.
Your Honor, if I could, in the interest of time, that motion's withdrawn.
Okay. All right.
For the record.
Very good.
Thank you.
So the defendant's motion for extension of speedy trial is withdrawn. Okay. So you guys ready to proceed with the rest of the motions? So yeah?
Yes, Your Honor.
Okay, very good. All right, so I have reviewed all of them. And let's start with the state's motion for pretrial ruling regarding admissibility of evidence. And I have reviewed that motion as well as the case law that's been cited by the state attorney's office. I'll just make a general note that pull up the case real quick. Specifically, I reviewed the Richardson case, Richardson versus State 338 7th 3rd 1106, and Hayes versus State 338 7th 3rd 1123. Those were actually co-defendants in a murder trial, I believe, out of Jacksonville. And the first DCA did a very extensive discussion in that case regarding when evidence of gang affiliation is relevant and admissible as having a probative value that outweighs any prejudice. So I just want to let you all know that I have reviewed that. Generally speaking, I'm going to let you obviously argue the motion. Generally speaking, the previous incident involving the shooting of the victim, Mr. Jones, where the shell casings were found that actually match shell casings that were found in Mr. Gathwright's search warrant, I think, of his home and car. My initial impression is that's admissible evidence. In the case as it relates to Ms. Andrews. I would note a distinguishing factor between Ms. Andrews' facts and the facts in the Richardson Hayes case. One, I believe the state in those cases was seeking a gang enhancement pursuant to the statute, correct?
Judge, that is correct.
And in this case, as far as Ms. Andrews goes, you were not seeking that enhancement, correct?
That is correct, Judge.
Okay. I would also note that the time frame was less as far as the amount of evidence the state was seeking to admit in Richardson and Hayes. I think that it was about a year and a half prior to the incident in the Richardson Hayes case that the state was permitted to get into the history between the warring gangs and the violence between them. Looking at the recitation of facts from the state in their motion, I don't know if you're seeking to admit all of that, but that's a much more extensive timeline than was granted in the Richardson Hayes case as far as the amount of evidence. So I would just note those are two distinguishing factors, and of note would be the fact that you're not seeking a gang enhancement against Ms. Andrews. So what I'm telling you is that at this point, I'm open to some of that evidence coming in, but not all that the state has alleged in their facts. I think we have to be careful that it not become a feature of the trial. There are incidents that would explain motive and intent and would give the chance for the state to explain the context in which they believe this crime was committed, but not everything that's laid out in your factual basis as to this defendant. Okay, that's at least my initial starting point, but I will hear argument, and I'm just letting you guys know what I'm thinking as I review the motions. So with that, go ahead.
AV Stat Media.
All right, that was fast. Why they put that in there, I don't know. Okay.
Based on Judge, and just so defense and Your Honor, it's clear, we do not allege in any way that the defendant that is first going to trial is involved in a gang or is a gang member or was involved in any of the history. So that is not ever going to be suggested or produced as evidence, Judge. This is clearly motive evidence that is inextricably intertwined. Judge, there are numerous back and forth between these rival gangs, and in fact, that Richardson case, the gangs involved actually are gangs that these current gangs out of Jacksonville evolved into, just so your honor is aware. But one of the reasons why, and we just picked 6 instances of the back and forth, because that goes specifically with the videos, in particular, the victim in this case, Charles Jones, who's known by his rapper name is Julio Foolio, produced 2 videos that are drill rap videos that are very well known. We posted in our motion. Both of those videos have over 1 million views. This is something in Jacksonville that is very well known. These videos, both by our victim as well as by the rival gangs, are posted immediately. It's in the public domain, and it details this long-standing feud. And so specifically with regards to the victim posting that is the motive for this crime. There is gang evidence that is intertwined in all facets of that case that we tried to outline in the state's motion as much as possible, how much it is interwoven. But it is also very clear by the evidence, direct and circumstantial, that the only reason that all 4 of the individuals, there's still one that is at large, came down to Tampa, and that was specifically to target our victim, Charles Jones. And the reason they're targeting him is because he is in this gang rival feud with these 2 other gangs, 1200 and ATK. And we have evidence of the defendant's co-defendants very clearly meeting at Sean Gathwright's house on his video camera, where they are loading up big bags that are definitely big enough to hold these assault rifles that were used in this case. So this was something that was intricately planned, and it was planned well before they came down here. And so while we do not allege that the defendant is part of a gang, it is certainly well known in Jacksonville, and she is dating Isaiah Chance, who is definitely alleged to be a part of the gang, and in his Cash App is known Mr. Rich Off of War. This is what this is about. This is a gang war. There was no other reason for any of these defendants to come down here, and it was a very sophisticated plan. They used AR rifles that had mesh brass catchers so as to not leave any sort of forensic evidence behind at our crime scene. Fortunately for the state, that homicide ended up being at a hotel that had video surveillance and had a Tesla that was there that showed an intimate view for the court. And I know that you're well aware from the pretrial detention hearing the type of firepower that 3 armed masked men were able to utilize to target our victim. And it was very clear from the video footage at not 1, not 2, but 3 locations that the defendant, along with all her co-defendants, were tracking our victim all through the night. And this conspiracy goes well before they come to Tampa. It continues after they come into Tampa. But this defendant in particular, she is the one who, before they come down here, tries to get an Airbnb in Tampa. That is found off of her Instagram, off of her phone, where she is trying to get someone else to get that. That falls through, and we all know eventually, based on the phone evidence from the co-defendant Rashad Murphy, that the Airbnb is actually booked utilizing his driver's license, and the defendant is not only tracked to that Airbnb in Tampa, she is seen on video at that Airbnb. In fact, she's the only person, the person not in the gang, who was shown up on that front door that has a Ring camera. There is a back door that does not have a camera, but we know after the crime is committed, 3 of the other co-defendants are seen with great facial shots of them at that Airbnb. She is tracked all the way from Jacksonville with the other co-defendants in 2 vehicles that are the exact vehicles. One is the tracker vehicle, the Chevy Cruze, and the Chevy Impala. So all of this evidence shows that she assisted, and she is actually one of the trackers. She is seen on video getting out with Isaiah Chance in that tracking video, the surveillance video that's tracking our victim, never going into either one of those 2 clubs but getting out of the vehicle, positioning herself along with her boyfriend in a position where they can see where the victim and his entourage are at that club. And after she makes eye contact, or is in a position where she can make eye contact, she returns to her vehicle, and then what happens? The second suspect vehicle shows up, and that suspect vehicle ends up being the vehicle with the 3 shooters.
And I don't mean to cut you off. That's all facts related to the offense. What we're talking about in your motion is what the state would be permitted to discuss what happened before the incident, before the murder of Mr. Jones. And so just looking at the facts as you lay them out in your motion in paragraph 3, you start with an incident that happened on August 18th of 2018, and you discuss another incident that happened in 2019, and basically that whole paragraph 3 all has to do with the Jacksonville gangs, the ATK, and then the 1200 gangs, who from my understanding are opponents of 6 Block and the Bully Gang. And Mr. Jones is alleged to have been a member of the 6 Block, and the 3 co-defendants, not Miss Andrews, are alleged to be members of or affiliated with members of ATK or 1200 rival gangs, right? So what I'm really interested in drilling down on is how much of this realistically, this history, are you really going to attempt to get into? I can just tell you, and I indicated that the shooting that occurred of the attempted murder of Mr. Jones, which appears, let me get that date here.
October 23rd.
October 23rd of 23, correct?
Yes, Judge.
So it was the year prior.
Correct.
And because due to the shell casings being a match, that does have relevance. And it looks like from your motion that this sort of kicked off in 2023, August 16th of 2023, that there was a gang member, Jaquan Pickens, who was a member of the Bully Gang, which would be an associate of Mr. Jones's purported gang, right? So he's shot and killed. And then there is an attempted murder on August 17th of 2023, which the state alleges basically was a retaliation, right, of Jacoby Beals, a 1200 gang member. And so then that shooting happens. These 2 shootings happen August of 2023. Then October 7th of 2023, Antonio Tilley, who's an ATK gang member, was murdered. Members from 6 Block claimed credit for that murder on social media. And on that same day that gang member Tilley was murdered, there was the attempted murder against Mr. Jones, the victim in this case.
Judge, we're not going to present evidence in detail of those murders. We do, and we have listed some gang experts out of Jacksonville, but those specifically go to the rap videos because I think it's important to motive.
In 2023, right?
Correct, Judge.
Okay.
Because and there were, I know that you mentioned the 2018, but those are some of the victims mentioned in the victims' rap songs as well as the rival gang. And so it's important for the jury to understand that they are rapping about what really...
previous incidents.
Correct. And that these are really real deaths, there are real shootings, and there's real retaliation that is a result of these drill rap videos, and that it is so well known in Jacksonville, and it is instantly put on social media after these deaths occur. And so, Judge, that, and again, we're not calling 20 witnesses from each of those instances to prove that they happened, but we do plan to elicit that sort of testimony as part of the explanation of the motive and those drill rap videos and what it means to this case.
Okay. And what I'm telling you is, and I'm assuming the evidence comes in, assuming you have a gang expert that has and you can lay the predicate for their testimony. What I'm saying is, particularly with this defendant, Miss Andrews, this needs to be very tight because you're not seeking a gang enhancement. She's not a gang member. I would note that in the Richardson case, and I'm just going to read from beginning at page 1117, There are two types of collateral crime evidence: similar fact evidence and dissimilar fact evidence. The former, also known as Williams Rule evidence, is governed by Section 90.404. The admissibility of both categories is determined by its relevancy and, of course, subject to exclusion under the balancing test of Section 90.403. In establishing its case, the state is entitled to present evidence which paints an accurate picture of the events surrounding the crimes charged, but cannot make the evidence of other crimes the feature of the trial or introduce the evidence solely for the purpose of showing bad character or propensity. Collateral crime evidence, regardless of its status as similar or dissimilar fact evidence, is admissible if it is inextricably intertwined with the charged crime. Collateral crime evidence is inextricably intertwined if it is necessary to 1. Adequately describe the deed, 2. Provide an intelligent account of the crimes charged, 3. Establish the entire context out of which the charged crimes arose, or 4. Adequately describe the events leading up to the charged crime. Okay, so, defense. Why is not some of this inextricably intertwined evidence?
So I do want to point out what the court has stated already, which is that Miss Alicia Andrews is not alleged to have been in any gang, she's not in a gang, and she doesn't have any gang involvement or ties. And so then the question becomes, how is any of what this gang has done in the past relevant to Alicia Andrews? It may be relevant to the other individuals in the case, but as it relates to Alicia Andrews, she's not out there shooting anyone. She didn't have any shell casings in her belongings or on her person that had anything to do with these other incidents, right? So the state wants, and again, I'm not sure if they want all or if we're just arguing about the one from October of 2023, but I will address all because all are in the motion.
Well, I can tell you, when it comes to Miss Andrews, just sitting here and listening and what I know after reading the motions and the case law, I do think specifically the events from the year 2023 do have particular relevance to this case, and they do explain the whole reason that the murder of Mr. Jones occurred from the state's perspective. It does explain the context. It does explain why these individuals came down from Jacksonville and specifically, as the state alleges, were tracking down, stalking Mr. Jones and why the shooting occurred. So I do find, generally speaking, that this is evidence that does help create motive and intent and explain the crimes charged. So as I told the state, I do think the events from 2023 do have relevance to this case. And I do think the probative value outweighs any prejudice to Ms. Andrews. But as I just told the state, if they're going to call a gang expert, I don't want this jury to get bogged down in a history of the war between these gangs going back to 2018. I don't have a problem with a gang expert identifying the gangs, that there's been violence committed between these gangs for a number of years. And in 2023 is when it, from what I can tell, really began ramping up with a series of back and forth revenge murders, leading up to the attempted murder of Mr. Jones and then ultimately the successful murder of Mr. Jones in 2024. So go ahead. No, you're fine.
So you mentioned that the gang expert may testify to those things. From what I just understood the state to say, because I'm not could be certain what the gang expert is testifying to, but what the state just said was a gang expert would testify to the rap videos. And so that's different from the history of the gang. I'm not sure where they're going with the gang expert, because the issue that I have is all of this evidence of the history, which we're arguing right now, who is it coming through? Like, who is going to testify to these things? How are they going to get around the various layers of hearsay? Are they just going to come in and play a YouTube video that goes over all of this stuff? I think there's other issues besides just the relevancy and the motive, but I do want to touch on the motive issue, which is that all of these individuals, their motive to do a certain thing or to commit this crime is going to be different. They don't all have the same motive. What's different between Alicia Andrews and the other defendants out there is that the state is alleging that for each of these other defendants, Charles Jones's gang has hurt or killed someone that they know and that they love, family members or best friends, right? So for Isaiah Chance, they're alleging that Charles Jones's gang, or maybe himself, killed a friend of his named Tilly. They're alleging that for the Murphy brothers, that one of their family members was killed by Charles Jones's gang or himself. Right? No one is alleging that Alicia Andrews had anyone that was killed and that she would then go back after Charles Jones and his gang or whatever with that motive for retribution or anything like that. So I think the motive needs to be separated from the individuals.
But she's charged as a principal, right?
Right.
But she's Isaiah Chance's girlfriend, right?
Isaiah Chance has, I think, maybe 5, 6 children, 5, 6 baby mothers. Like,
at the time was one of many
that Isaiah Chance was dealing with, and so it's not like they're Bonnie and Clyde and they ride out every day, all day together, right? They do need to be separated. They don't have the same motive. I don't, and just because she's charged as a principal doesn't mean she shares the exact same motive. That the evidence against Isaiah Chance that's relevant to him and would show his motive is also relevant to her and would show her motive. The other thing I want to discuss is the case law that the state cites to in their motion, Richardson and Hayes. Those cases are distinguishable because the defendants in those cases were involved in gangs.
Right.
They were.
I noted that.
They had rap videos of their own that were played in court because they're the ones saying these things about the beef and back and forth. Alicia Andrews is 10 steps removed from that. She's not in the gang. She doesn't have any rap videos. She's not talking about killing anyone. So I think the two cases are completely different. These are uncharged crimes. They're coming in for the purpose of, they're really prejudicial to Miss Andrews. It's hard for it not to become a feature of the trial. In order to explain all this stuff, it's going to require several witnesses to come in to testify and say, hey, this happened on this date, and this happened on that date, and this is what happened here, and this is why it happened, and this person was killed, and that person was killed, and then he went back and forth. That's going to become a feature of the trial. It doesn't take 2 minutes to kind of describe that. But I think the core of your question was whether the October 23 incident is relevant for motive for Alicia Andrews. Again, there is no evidence that Alicia Andrews was on the scene during that murder or attempted murder during that shooting. There's nothing tying her to that incident. I don't even know if at that point she was with Isaiah Chance.
Right.
And so for the state to argue that that is relevant, like it is relevant to maybe Isaiah Chance or Sean Gafford, who had evidence that they were tied to that crime, but Alicia Andrews has nothing tying her to it, so it's, in my opinion, completely irrelevant. It doesn't show her motive. It doesn't show why she got in the car to come down. It just, to me, it's irrelevant as it relates to Alicia Andrews. And the last thing I want to say is that these rap videos, they're not all accurate. They're not all true. I mean, it's the best example.
Which makes them not hearsay. If they're not offered for the truth of the matter, it makes them not hearsay.
Well, that's my argument. But the state is arguing that those rap videos are accurate and true because the rap videos would show that this gang is in conflict with this gang and whatnot. So they're offering it for the truth. I'd be arguing that it's not truthful. By way of example, after the shooting in this case, there's a rapper, Youngin Ace, who gets on YouTube the same day that this happened and takes credit for whatever happened in good detail. The lead detective says he has no real evidence that that rapper, was even involved in this case. And so we have all these, I don't know what rap videos they're actually trying to bring in. I guess that's another topic.
Yes, that's another topic. Well, at least it's a discussion for another day. But I'll let you go and finish.
But I mean that's pretty much my argument. I don't know how they get through the various layers of hearsay and what witness they're actually going to put on to testify to this history.
Well, state, Ms. Doherty, who are you intending to establish the gang connection?
Judge, we've listed 4 experts in gang activity, but we only anticipate maybe calling 1 or 2 of them.
Okay.
And they've been listed in their expert capacity.
So through an expert.
Okay. So I guess if we're narrowing it down to the Sean Gafford, not the Sean Gafford issue, the October 2023.
Well, I'm narrowing it down to 2023 at this point. Okay, as far as the events, because just looking at the state's recitation of facts, it would appear that the year 2023 is when the kickoff of the tit for tat, the payback murders between these rival gangs really flared up from what the state has alleged. And so we're going to discuss this momentarily, but the state is going to have to identify exactly which of these rap videos that you intend to admit. And I'm going to encourage you now to be very selective. And keep in mind that this, as I've said, I'm not saying that a gang expert would not be at all permitted to reference an event in 2018 or an earlier year if it explains a comment made in 2023 on a video. But again, with regards to Ms. Andrews, this needs to be limited in nature so as not to be viewed as a feature of the trial. So state, I'm going to need you to take a look at all of the rap videos that you have that you think would be admissible as they relate to Ms. Andrews, and you need to identify them specifically. And then defense, you can renew any objections to any specific items of evidence with regards to your objections. So, but I'm going to encourage the state to be conservative right out of the gate, because at some point it's going to become tip over from Ms. Andrews from probative to prejudicial if it's rap video after rap video after rap video. Really, for Ms. Andrews' purposes, it's really more of a setting of the table, explaining why this incident occurred. Again, you're not seeking a gang enhancement, so the level of detail is not required because you don't have the same burden of proof as far as that enhancement goes. So when do you think you'd be able to get those items of evidence identified, the actual rap videos you intend to use and to get admitted through one of your gang experts? And I guess I should also go ahead and ask the question, when do you think you'll have your final, actually going to call at trial witness list?
And Judge, I do have one more thing to add, but I'll wait until...
Sure. When something comes to my head, I got to ask about it, or else I'll forget to ask it. So,
AV Stat Media.
Judge, I think we'd be able to do it by the 2nd, January 2nd, a completed exhibit list.
And witness list?
And witness list, yes, Judge.
By 5 p.m.?
Yes, ma'am.
Okay. So you'll know then, defense will know by 5 p.m. on January 2nd, as far as which of these rap videos they intend to introduce into evidence through their identified gang expert, and on their witness list, they will identify who's going to be your gang expert that's going to testify.
Yes, Judge.
Okay, so you'll know. And then once the state has identified the rap videos, you can then renew any objection as to any specific items of evidence.
Okay, so as far as, I guess, the state's motion right now, are you holding it in abeyance until that?
Well, I'm granting it. I'm granting the motion in part specifically as to conduct that occurred in 2023. Okay? So conduct that occurred in 2023, the acts of violence between the parties, the rival gangs, I find is admissible. Collateral crime evidence is being inextricably intertwined. However, subject to, but it's without prejudice for you all to have the ability to renew any specific objections to any specific items of evidence once the state has given you their exhibit list.
Okay. And just, I guess, two things, but the first, just so that I can properly renew the objection at the appropriate time. The court's ruling is that it is inextricably intertwined. There's 4, I guess, considerations.
Right.
And I wanted to know which of those 4 I need to renew my objection about. Like, what do I, because Once I get the extra information, then I want to.
Okay, so here are the 4 factors for collateral crime evidence to be deemed inextricably intertwined. I find that it is necessary, 1, to adequately describe the deed. I find it is necessary, 2, to provide an intelligent account of the crimes charged. I find it is necessary, 3, to establish the entire context out of which the charged crimes arose. And I find it's necessary to establish for the state to adequately describe the events leading up to the charged crime. So I find all 4 factors of admissible collateral crime evidence as being inextricably intertwined apply in this case.
Understood. And then the last thing I wanted to mention, because I forgot to mention this earlier, is that the state argues, or puts in a motion at least, that Isaiah Chance is a member of the ATK gang, and that he's a documented member of that gang. I don't know where that is coming from. I did depose the lead detective in the case, Juan Ramos. It wasn't clear from his deposition that Isaiah Chance was actually a part of the gang, as opposed to just kind of hanging around different gang groups and sort of like ATK. There's no real, I guess there's no concrete affiliation with them, as opposed to them just being maybe his friends or acquaintances or whatnot.
Okay.
So I think that also removes.
Well, State, what's your response to that as far as Mr. Chance's gang affiliation and or membership?
Judge, we have listed gang experts. They've not taken any of the depositions of those officers from Jacksonville that are specifically listed. So.
Okay. I'm assuming it's going to be through one of their gang experts. They're going to let you know by January 2nd. Do you know today which gang expert you're going to be calling?
Judge, I believe it may be Drabeck and Nieder, but I'm not 100. I think Ms. Ismer was going to cover that part of the case, and I know that she's had preliminary talks, but I'm not sure. But there were 4 that were mentioned and specifically listed in discovery. In Detective Ramos's deposition, he specifically said that that's where they would find that information, would be from the Jacksonville gang unit. So.
Okay, well, that's your answer. It's coming in allegedly through their gang expert. Okay? All right. Okay. Anything further? So as to that motion, then it's granted in part as I indicated. All right. Let's see. Next up, state's and you can sit down, Mr. McLymont. State's motion in limine. State's motion to exclude defendant's self-serving hearsay.
Your Honor?
Yes.
My apologies. Just before we completely move on, can I just ask the court a question, please?
Sure.
I do understand that the court did just rule that they would have until January 2nd to go ahead and provide to us the qualifications of who actually would be considered the gang expert in the videos that they plan to use. Because this motion was just filed not too long ago, I did want to ask the court if the court would be willing to consider at least letting us know who, maybe a little bit before the 2nd, because if they already had a list of who they already were, right, I believe they should be able to reveal that to us, because it puts us in a bad position to be able to depose them.
Yeah, I hear you. Yes. So your point's probably well taken. I don't have my calendar. Hold on one second. So State, you guys need to make the call on your gang expert. You have to identify your individual who's going to testify as a gang expert by 5 p.m. December 27th. Okay. The other, your final trial witness list, your final exhibit list can all be filed by 5 p.m. on January 2nd. Your gang expert has to be identified by 5 p.m. December 27th. Okay?
Yes, Judge.
Okay, so State's motion to exclude defendant's self-serving hearsay. Is this just a general motion, or are there specific comments?
No, it's a general motion, Judge. These are boilerplate general motions. From the tenor of the depositions, I felt I needed to file these motions.
Okay.
So this would be to exclude any attempt by the defense to introduce self-serving hearsay of the defendant that we haven't already introduced.
Okay. So, any objection?
Yeah, no real objection because of the last caveat that he made. So if it's something that they've introduced, if it's something that that would engage the rule of completeness, then I would ask that
Sure.
that be admitted.
That's fine. So I'll grant the motion with the understanding that the defense reserves the right at trial if you wish to seek admission of self-serving hearsay as part of the rule of completeness. We just need to discuss it before you do it. Okay?
Understood.
All right. So granted, but reserve ruling for at trial for the defense to raise a specific objection. State's motion for a comprehensive and complete witness and exhibit list from the defense. So you all need to also meet, have you?
I'm sorry, my apologies for my voice. What we did file was a notice of intent to utilize
the state's
mutual, witnesses, Your Honor, but one of our motions today was as it pertains to like the confidentiality and the way we would address a particular witness if we were to have one given the circumstances.
Okay, so I did have a question about that because you've already identified, at this point, the only witnesses you have identified are the ones that the state has identified, correct?
Correct.
Okay, so there's no other witness list you're going to be filing, correct?
Well, no, I'm not saying that, Your Honor.
Well, okay, we're set for trial. So when were you going to file your defense witness list exactly?
Your Honor, I want to be transparent with the court. I want to make sure that anybody that I would file for a defense witness list is would actually show up, and I'm still doing a little bit of investigation because it just came up.
Judge, we can take the same date that the state has for the witness list.
Yeah, but the problem is you've got to put the state on notice who these people are so they can depose them if they wish. So the state's already identified all of their witnesses. Their January 2nd deadline is just to identify to you all who they're actually going to call from a witness list they've already disclosed.
So I think most of our witnesses, if we're calling any witnesses, would come from the state's witness list. If there's a defense witness that the state does not know about, we can take an earlier date to
okay.
disclose that.
Okay.
So we'll
you guys, defense, can you all live with December 27th?
That's fine, Your Honor.
Okay.
The court stated we need to have time to depose a witness. So that's fine, Judge.
Yeah. So December 27th by 5 p.m., if there are any witnesses the defense intends to call that aren't on the state's list already, you must identify them. And we'll talk about how you're going to identify them, but the state's got to know who these people are so they can depose them if they choose. We're bumping up against a very close trial date.
Judge, the state also under that motion would seek from the defense a list of who they intend to call at trial, just as the state's been required to do so. We'd ask the same thing be asked of the defense, not just an all states witness list. As the court knows, that's insufficient notice to the state. We would ask for who they're going to call at trial.
That's what I just said, though. So I would take the same date that you
January 2nd. Or did I say 2nd or 3rd?
Second.
Second. By January 2nd by 5 p.m., the defense also needs to submit a list of the actual witnesses they would intend to call at trial, as well as any exhibits they would attempt to introduce at trial. And if there are any exhibits that you're intending to introduce that are not from the state's evidence, you need to identify that by December 26th as well.
Understood.
Okay?
The 26th or the 27th, Your Honor?
I'm sorry, 27th.
Thank you.
Okay.
And then you said exhibits, Your Honor?
Yep, if there are any exhibits that were not disclosed to you by the state, meaning brand new exhibits, no one besides you guys have ever seen them, those need to be identified by 5 p.m. on December 26th. And then 27th, I keep saying that. 27th.
Judge, I would be amenable. Defense is if we want to meet on January 3rd, both sides, to show each other all of the evidence and exhibits that we intend to use in trial.
Okay.
We usually do that at evidence viewing.
Would that be in addition to the 27th?
No. The 27th is just the December 27th is just for the state to file some type of notice of who their gang expert is. That's what they've got to do by 5 p.m. You all, meaning the defense, must, by 5 p.m. on December 27th, identify any witnesses that you're going to call that are not on the state's witness list, and identify any exhibits you would seek to introduce that are not in the state's discovery. Anything that's coming just from the defense must be identified by 5 p.m. on December 27th. January 3rd by 5 p.m. is when both sides need to finalize their trial witness list and their trial exhibit list. And I do think it's a good idea for you guys to meet and confer. That's what I would suggest that you do.
Judge, you just said 3rd, but for the record, it's the 2nd, right?
Hold on, let me take a look. Whatever that Friday is.
No, those are two different. The Friday's the 3rd.
The Friday's the 3rd. If I said the 2nd, I meant the 3rd. December 27th, gang expert, defense witness exhibits that no one's ever heard of besides you guys. 5 p.m. on January 3rd, final trial witness list, final trial exhibit list for both sides. And you guys should really meet and confer on January 3rd to go over and look at each other's exhibits. And then if there are any specific...
We're agreeable to that, by the way.
Okay, so I'll let you guys work out the details.
Yes, Judge.
And then if there are any specific objections, I will address them the following week. So we'll have time for me to rule on them before the actual trial begins. Okay? All right. Next up, state's motion to prohibit any argument or inference concerning the failure of the state to call equally available witnesses. Defense, any objection to that one?
No objection.
Okay, that one's granted. State's motion to prohibit any reference to or argument concerning any internal affairs investigations or issues or other disciplinary actions related to any state witness.
Judge, that seemed to be a very frequent question asked of all officers that have been deposed by the defense. So I wanted to make sure the defense understands the legal limitations of what's admissible at trial, because we had a couple of officers who have had disciplinary actions or internal affairs things that have occurred in the past.
Right. And the case law states that courts have allowed cross-examination on internal affairs investigations where the investigation arose from the same incident as the defendant's criminal charges, or if a defendant claims an officer used excessive force and the investigation involving prior incidents of excessive force, but they have refused to allow such evidence when the investigation is completely unrelated to the defendant's case. So,
Yeah, Judge, the case that the state cites, the Breedlove versus state case, I think that is the case that I agree with the case because it is a Supreme Court case. We would only introduce that information if it is relevant, as it's not too remote in time and it's related to the case at hand. I think that we're going to follow the law as it relates to that motion.
okay, so if you guys are intending to cross-examine any officer with internal affairs investigation material, you have to identify that by January the 3rd at 5 p.m. as well. And then that way, if there's going to be a dispute over it, I can rule on it before the witness takes a stand.
Your Honor, can we have some clarity on that, please? As the state just mentioned, they do or may have some witnesses that do have these issues. This came up before in some at a previous hearing. I don't believe we've been fully disclosed to everyone that has the internal affair issues. So is it a possibility to get the deadline for that sooner than the date that you just gave us?
To get what are you?
Is it possible for us to get a date sooner than the deadline?
What do you think you're missing? First of
a
all,
list of who has been
okay, no, you're not entitled to just go on a fishing expedition. So if there are internal affairs investigations related to the conduct of officers while investigating this case, clearly relevant, okay? But this is not just going to be a fishing expedition. So,
I understand, Your Honor. Well, can I also ask for the court's clarity on this? Also, because we just heard the other motion wherein we're bringing in everything from 2023, are we then allowed to question the officers conduct that would have been related to any of the people in that particular motion?
No.
Okay.
No. No. Okay. All right. Okay. So that's that on the state's motion in limine, and there's a motion, state's motion for protective order. So, yeah, who's arguing that motion for the state?
Judge, this was Ms. Ismer's motion. She was in trial this week. I am familiar with the subject matter, so I can go ahead and speak towards it. Judge, this happened during a deposition that Ms. Ismer was attending on behalf of the state. It was one of the listed victims of the attempted murder, Camilla Bentley. Those witnesses, there are victims that have been live witness victims that have been listed in compliance with the rules. They have been listed, and a notice of confidential victim information has been filed along with those. The defendants have been provided with their addresses that are not subject to public records requests. Just because of the nature of this case, we're trying to protect those victims. There were questions in a deposition that Ms. Ismer did not want placed in the deposition when it had to do with how that victim could be identified, like addresses where they work, their current addresses. And I can't remember if she stated, and defense counsel can correct me if I'm wrong. I know that there was some talk about certifying it or not putting it on the record. I'm not sure if the witness actually stated it on the record in that deposition, but if so, I think Ms. Ismer's concern, and rightly so, is that it's fine for defense counsel to have that, but that is not something, again, that should be disseminated, copied, sent to a jail or anything of that nature. That information should be redacted. Again, that is information not subject to public records requests. It's confidential for a reason. It's required by statute, and so that we would ask that that continue to be the case, Judge. If those depositions are produced, we certainly don't want them disseminated.
Well, specifically, Ms. Ismer in her motion at paragraph 5 asks, the state files this formal motion to prevent disclosure of any sensitive information from disclosure outside of the attorneys participating in this action. More specifically, the state requests that the attorneys be permitted to order and review a password encrypted deposition transcript of the lay witnesses and victims, and that the information included therein be ordered as attorney access only, prohibited from disclosure in any format to any person other than the assigned attorney. Do you have any objection to that?
Well, I do. I guess the way that they're kind of restricting it. For one, I'm not like opposed to a protective order for some of the discovery, because it happens, and in federal cases we have like a standard protective order. Just the way that I guess we have to have a like myself, I have to have a password encrypted deposition. I mean, I guess I could figure that out, but I don't even know how to do that.
Me either.
Me either. So and then who gets to have the discovery is also my issue. So it shouldn't just be the attorneys. I have staff. I have
right.
Actually, if we do have an expert, right, we would want them to be able to have it. And then we want Ms. Andrews to have it. The way that the protective orders work to prevent things from getting out of the jail is if I'm going to provide Ms. Andrews with a deposition transcript in the jail, she can have it, but we redact sensitive information out of it so that it can't, be disseminated in the jail. Not that she would do it intentionally, but people grab people's things all the time. So I think if we're going, I guess what I would agree to is this. I would agree to a protective order that does that as far as if I want to send any discovery into the jail for Alicia Andrews to review, that I have to redact sensitive information from that. I'm in agreement with that. I'm also asking, I'm not in agreement with the password encrypted transcript. And then.
Okay, so here's what I'm going to do. I'm going to grant the motion in part and state what you or Ms. Ismer or whomever is going to have to do is you have to identify with specificity which of the witnesses and or victims, which of the witnesses this applies to, and specifically what information needs to be redacted out. And this would be any identifying information, date of birth, social security number, work address, home address, telephone number, anything along those lines must be redacted out. And these depositions of these witnesses cannot be disclosed to any non-party to this litigation or this case. So just draft an order and run it by defense, and if you guys agree, just upload it and let me know. I'll sign it. If you disagree, let me know what the disagreement is, and I'll work it out.
Yes, Your Honor.
Okay. Okay, so granted in part as indicated. Okay. Okay. All right, I think that's it for the state's motions, correct?
Yes, Your Honor.
Okay, so moving on to the defense motion. The first motion was defense's motion for a comprehensive and complete witness and exhibit list, but I think I've already ruled on that one.
All right, so like I said, there was part 1 and now there's part 2. So let's get to part 2. I don't know why they cut it in half, but they do. So same day, part 1 and part 2. And this one's about an hour as well. And then we have a 15-minute one, and then we'll end this stream. And then we'll pick up on Alec Murdoch. Our ego takes the stand. We still have to finish that. So we'll break for lunch, and then we'll come back and watch that. So this is about an hour, and then we have a quick 15-minute one, and then we'll take a little lunch break. Because it is Pizza Friday after all. I'm so happy. I love my Pizza Friday. All right.
All right, you guys ready to proceed?
Yes, Judge.
Yes,
Okay.
Your Honor.
Okay, very good. So we were on defense's motion for a comprehensive and complete witness and exhibit list from the state, and I feel like we've already addressed the issues contained in that motion,
Your
correct?
Honor, if I may?
Sure.
Just in the interest of time, would you like me to stand or is it okay if I sit?
Sure.
Yes,
You
Your Honor.
can remain seated. It really doesn't matter.
Oh.
You're fine. Just as long as I can hear you.
Yes, ma'am. Thank you. So, Your Honor, based on some of the motions and things that have already been addressed, I will be not moving forward with some of these motions that were previously set. The ones that I plan on moving forward with.
Well, let's do this, just because for my own sake,
Yes.
I have these in a list of how I reviewed them,
No problem.
and it just helps me. I'll identify the motion, and you just tell me if you still want to go forward with it or not.
Yes, Your Honor.
Okay, so we're on defense's motion for a comprehensive and complete witness and exhibit list from the state. And I feel like that one has been addressed, basically.
I agree, Your Honor.
Okay, so at this point, it's granted as I've already established. Okay, next up. Defendant's motion to permit confidential testimony of witnesses for safety reasons. I'm assuming you want this one heard, correct?
Yes, Your Honor, but may I choose the order of which I do argue them because the motion and eliminate.
Sure, we'll come back to that one. All right, defendant's motion for individual and sequestered voir dire. I'm not going to sequester this jury, but I can tell you, I will do individual voir dire regarding anyone's knowledge of anything related to this case. And it will be similar to how I handle every other high-profile case I've ever tried. We will hopefully be picking our jury in courtroom 1. I'll probably have to bring in a bigger panel than normal, just due to the fact that this is a high-profile case. Whatever that number is that we think we'll need, bring them in. And I will initially have you all just write down names and numbers, juror names and numbers. And then I will bring everybody in and I will ask anybody who has any knowledge of the case to raise their hand. Those individuals that don't raise their hand will be excused or allowed to go back outside and do whatever. We'll see what time it is. Maybe send them to lunch, who knows. But excuse those who don't know anything. And then the ones that did raise their hand, I'll just start with whatever the first juror is. That person will remain in the courtroom. Those that know anything about the case will step outside into the waiting area, and then I will question them one-on-one. Okay? So I will ask them the initial question: what do you know? What have you heard? Where did you hear it? Is it going to impact your ability to be a fair and impartial juror? And then I'll give both the state and the defense the opportunity to ask any follow-up questions, and we'll do that process for all of the jurors that know anything about this case. So I will grant this motion in part as to individual voir dire as to their knowledge about the case. However, once that part is done, if there are any individuals that are obviously gone for cause that you all agree on, then I will excuse those individuals at that time. The ones that remain will then bring in the rest of the panel that didn't know anything about the case, and then we will proceed with just regular voir dire. I will also instruct all of the panel members from the moment they're sworn in that from this moment forward until they're excused, they're not to read, listen to, watch any news accounts, talk about anything related to this case with each other or anybody else. Okay? So is that acceptable to the defense?
Yes, Your Honor.
Okay.
Thank you.
So the defendant's motion for individual voir dire is granted as to individual voir dire for knowledge of this case, and it's denied as to sequestering the jury. Okay, very good. All right, defendant's combined motion in limine.
Yes, Your Honor, I do want to move on with that one.
Yeah, I mean, it looks like most of these are basic tenets of the law, right?
Correct, Your Honor. I'm aware that after I was reviewing everything, that everything that was inclusive with it is not quite listed as for my argument. I would ask that Your Honor allow me to do oral arguments as well, or reserve on this issue.
On all of these or some of these?
No. Well, I do want to ask for very specific motion and limines as it pertains to the lead detective, Your Honor. And
so is that contained within this motion, or are you filing an amended motion?
It's contained within this motion, but
which paragraph?
It's not explained the same way that.
Okay, well, tell me what paragraph,
1 second, Your Honor.
And then we'll go from there.
Okay, so.
So maybe this will make this easier. Okay, if I do this. So looking at items in your motion 1 through 10. I mean, those are very general, basic propositions as far as inadmissible evidence goes. So the same way that the state kind of filed a boilerplate motion in limine, I'll grant your motion in limine subject to, without prejudice, the state has the right to discuss any evidence that it would seek to admit that maybe on its face might be violative of one of these, but these are basically, these are very, basic boilerplate motions. For example, 2, exclusion of hearsay statements. Yes, hearsay testimony, generally speaking, is included, but there may be hearsay exceptions. So this doesn't prohibit the state from seeking to admit hearsay statements if there is an exception that they can establish, that kind of thing. So the motion in limine is generally granted, subject to revisiting if necessary during trial. 11, exclusion of social media evidence. I'm denying that. I'm not just going to exclude all social media evidence. Either side can seek to admit social media evidence, assuming it's admissible, relevant, and they can lay the predicate. Exclusion of cell phone location data. I'm going to deny that one. Again, that type of evidence is admissible if the moving party can lay the predicate for it. Exclusion 13. Yep.
Your Honor, if I may, basically, I don't have, I understand Your Honor's ruling as pertains to the motion of limine being boilerplate in 1 through 10, but I am requesting at this time for the court to allow me to specifically request motion in limine as it pertains to the speculative nature of lead detective Ramos. And what I want to utilize for that, Your Honor, is the transcript from the pretrial detention hearing specifically, because it's already a part of evidence. It's already a part of this case from the very beginning. And I do believe, and starting on page 97, Your Honor, if Your Honor would allow, there are some very specific things I did want to have.
Okay, sure. So what paragraph are we referring to? Paragraph 3?
Yes, Your Honor. So as it pertains to my motion, paragraph 3.
Okay, so specifically...
But specifically
yes.
As it pertains to the transcript...
Of which witness?
Of lead detective Ramos.
Okay. And this is from whose pretrial detention hearing?
This is actually all the co-defendants, Your Honor.
Okay. And what did he say at that hearing that you're objecting to?
So what we're if I could call Your Honor to review,
Well, I don't have a copy of the transcript, so you're gonna have to show it to me or read it to me.
Not a problem. I have several copies of this in here.
You could just read it to me.
Oh, okay.
Just read it. It's fine.
Yes, Your Honor. So specifically, at this time, during this hearing, this was prior to the time I and my co-counsel were Ms. Andrews' attorneys. So there was the public defender that was present for this and made these arguments. I just wanted to notate
Was this at the pretrial detention hearing for your client?
All of them were at the same time. Now.
Well, actually, they weren't, because Mr. Murphy had his own pretrial detention hearing, which I
my
heard.
apologies for that.
Okay.
My
That's fine.
apologies for that.
Three of them were.
Yes, it is.
Okay.
As it pertains
In
to
front of
my
Judge
case.
Sabella, right?
Yes, Your Honor.
Okay, very good. What page?
Yes, Your Honor. I'm starting with page 98.
Okay.
Okay. No, my apologies, Your Honor. Starting with page 97.
Judge, I'm sorry, I do have a copy of it. I didn't bring it with me because it wasn't specifically mentioned in their motion. Do you have an extra copy for me?
We can make it happen.
Thank you.
Yes. It's all. Yes, I have the highlighted version. It's specific. Yeah, that's all.
Thank you, I appreciate it.
No problem. Your Honor, if I have a moment, because I'm having internet.
Sure.
1 second, please. Thank you.
Might be able to pull down my phone. It was a while ago. Was his name? It has to be Pretrial. I have a second.
Oh, that's right.
I said that twice to you. I think I have it. I don't know if I sent it because it's very specific.
Thank you, Your Honor. We're just pulling it because I'm having some connectivity issues.
Sure.
Since I did get my physical copy. But thank you. Thank you for your patience.
Okay, so maybe to move this along, State, have you had a chance to review the portions of the transcript that were handed to you? And if
Judge, if she reads it out loud.
yes,
that's
okay,
fine,
let's
Judge.
do that.
Yep.
Okay.
She was looking for a highlighted version.
Yeah, because I had it right there. You can keep it if you want.
No, you can have it.
Okay.
I'll listen.
Okay.
So starting with page 97, Your Honor, line 21, page 97. The question for lead detective Juan Ramos was, okay, let me ask you this question. What is your specific evidence as to the specific acts taken by Ms. Andrews that she acted as a principal to first-degree murder? Detective Juan Ramos's answer, line 25, was, so her phone evidence that Mr. Chance used was her phone. We were able to positively identify it as her phone. She provided her phone to Mr. Chance to be used, which was crucial in communication between the Silver Cruise and the Impala. Also, the Airbnb, when she was the only one seen arriving, so she, the assumption there, the presumption there, was that she opened the back door because the front door camera would have activated, and then she attempted to book an Airbnb from her Instagram account, which ultimately failed and led to one of the defendants having to book the Airbnb under their name. Those are some of the actions that she took to contribute to conspiracy and plot to kill the victim.
Okay, so generally speaking, and this was a pretrial detention hearing, right, where the state's got to, they're essentially establishing that there was probable cause as far as why this defendant should remain in custody, which is different from trial. So no law enforcement officer is going to be able to come in here and say, well, based in my opinion upon such and such evidence, this person was a principal, because that's the ultimate determination that has to be made by the jury, not by law enforcement. Law enforcement can come in and testify as to the facts as they witness them or develop them, but they can't render ultimate conclusions regarding the guilt of the defendant. So,
And yes, Your Honor, I do agree with you actually on that. I'm sorry.
You're not going to ask law enforcement to render an opinion regarding the guilt of the defendant, correct?
No, Your Honor. I think that was a defense question, to be honest.
Oh, okay.
There's, if I may, Your Honor?
Sure.
Continue. Okay.
Well, since it's not an emotion, I'm trying to determine what exactly it is.
We're trying to exclude all his speculative statements, because he said it in he said it in his reports, he said it in the pretrial, and he said it at deposition. And it's very specific here, Your Honor, on every page, from page 98 to page. It's very specific, wherein he actually specifically admits that everything that he knows is an inference, a reference, or a presumption. And to make it easier for Your Honor, I will just go down to the last question, wherein he states,
what page?
Yes, Your Honor, I'm just scrolling. Okay. It is page 108. Or no, it starts at 107, my apologies. No, it's 108, my apologies, line 7, Your Honor.
Okay.
The question for Detective Ramos was, okay, and again, her knowledge of what happened, her knowledge of the shooting, or that the shooting was going to take place, those are all assumptions that you're making, correct? That she had knowledge of this. His answer in line 12 was correct. Now, mind you, Your Honor, there was a lot of investigation and it moved fast with this. He had already had her over 2-hour,
AV Stat Media, all 4K.
did actually present an entire PowerPoint at this pre-detention hearing and actually admit evidence of some of the videos that were mentioned, I believe, today, as well as some of the evidence. And a lot of these things were also repeated in the deposition that we took. So what we want to do is bring awareness to this matter and point out to the court that we don't believe that Detective Ramos should be able to make any speculative testimony, as he's already admitted that everything as it pertains to our client Alicia Andrews' knowledge of what happened, the shooting, or the fact that the shooting would take place, which also would show intent or motive, basically anything that has to do with this, Your Honor. And if you read any of the pages in between, as I'm sure the court will review, you'll also see where the defense attorney at that time actually breaks down each segment, the phone, the Airbnb, and on every single topic under oath, the lead detective here is saying that our client is not involved. Or it's speculative, he has no proof. And I would go line for line, but...
Okay, well, that's okay. I mean, no witness, and I'm just going to reiterate what I said, was that no witness can come in here and speculate as to anything. Witnesses come in and they can talk about what they observed, what they heard, and with regards to the detective, he can testify as to what he did as far as his investigation goes. He can't conjecture about the defendant's guilt or innocence, so that's not going to happen. So...
As far as, I understand that, Your Honor, but as far as her guilt or innocence, or as far as her involvement, her motive, or any of the other elements.
Yeah, he can't speculate on that. No one can speculate at all. Nobody can. Okay? So again, this will be another situation where, generally speaking, I'll grant the motion, but it will be subject, it's without prejudice, to readdress at trial as the evidence comes in. So if Detective Ramos is testifying and you think that he's speculating as to something, you need to renew your objection at that point, and I'll rule on it.
Judge, can I jump in first?
Yeah, sure.
So the general, I guess, speculation objections will make contemporaneously at the trial. There are some, though, that we want to clear up way beforehand because I think that they're important and the state's heavily relying on them. Just for example, the Airbnb situation. And the state mentioned it earlier when they were going through the crime itself. And when I say the Airbnb, I mean what the state's theory is that Alicia Andrews goes to this Airbnb and that she goes in the front door and lets everyone else in through the back. So they don't have actual evidence that that is what happened, but that is what they've been saying from the beginning of the case and throughout the reports. That's what Detective Ramos believes based off of his own speculation and assumptions. Right? There are a bunch of things that could draw that conclusion, but there are other things that would draw the conclusion in a completely different way, which is speculative. So when you get to the Airbnb, there's supposed to be an individual, the owner of the Airbnb, that sends a code through an app, and then you're supposed to be able to go into the Airbnb with that code. In the video that the state has of the Airbnb, of the Ring camera, it doesn't show Ms. Andrews putting in any code or sort of receiving any code from an individual, and so she knocks the door and it opens, suggesting that someone is actually inside letting her in, not the other way around.
Okay, but this all sounds like what you guys are going to argue before the jury.
Well, I don't want to argue Detective Ramos's speculative thoughts that Miss Andrews let the people in through the back because he doesn't have any evidence of that. And
I understand.
In our view, everything that we know, that's not what happened. So that's one thing, and then like another thing is that she booked the Airbnb. She tried to book the Airbnb through another person so that that person's identity would be used for the Airbnb. It's also speculation. And if it makes it easier, what I can do is I can file a motion with these specific issues, if it's not too late, deadline purposes and whatnot, with these specific issues so that we can kind of ferret them out before trial. I think it's about 5 or 6 specific things that we don't want Detective Ramos testifying to because I think they are pure speculation.
Well, the facts underlying what happened at the Airbnb, all of that he can testify to, but he can't draw ultimate conclusions.
Right. I think he can testify that she is on the video and she goes into the door.
And he can testify that the back door did not have a Ring camera, that there was a back door. I'm assuming he knows that, right? He knows there was a back door. He knows there was a Ring camera, so he can testify to that. And he can testify that when the Uber picked them up, surprisingly now, even though the only person caught on the Ring camera at the front door was Miss Andrews, the other co-defendants are now all piling in the Uber to head back to Jacksonville. Not all of them, because one went to Orlando or somewhere to drop off a car. But stuff like that. He can testify to all of that. And then it's up for the jury to determine what the facts actually are. So, I mean, I feel like we're on the same page about this. State, you have any response?
Judge, obviously we can argue to the jury in closing argument what the inferences are, but I know not to have elicit any sort of opinion, a testimony from the detective. Judge, I do intend to ask him about his investigation and his observations. Judge, there also, just for full candor to the court, there is a discussion of this very thing on the defendant's interview, which I believe that also comes in, and there's a jury instruction that talks about the officer's opinions or whatnot, but certainly I did not, and they've not asked me to take that out when we discussed the defendant's interview. Like, that is in there, the discussion about the Airbnb.
Okay.
Well, she denies the version that the state is putting forward.
Okay.
But
listen, guys, we're getting far afield. So if there are specific issues that you want to identify from either Detective Ramos or whoever, that's fine. But again, the general ruling is going to be no one can speculate on what the facts of this case mean. Only the jury gets to determine that. The witnesses come in and they testify as to the facts as they know them, as they witnessed them, saw them, heard them, whatever it may be. Okay? So anyway, so we're back to where we were on item in your defendant's combined motion in limine, item number 3. again, the ruling is the same. It's granted without prejudice to readdress at trial as to specific evidence as it is admitted in court, or attempted to be admitted in court. Okay, where was I? I think I was item 13, exclusion of digital forensic reports. I'm going to deny that one, again, without prejudice. If this predicate isn't laid for the admission of that evidence, it can be renewed at that point. Exclusion of inflammatory crime scene photo or forensic photos. I'm going to reserve ruling on that one. So you guys are going to have to just see which photos the state seeks to introduce, and if you want specific ones excluded, you have to identify them and tell me why. Prohibit mention of uncharged conduct or allegation. That one as denied pursuant to my ruling on the state's motion in limine regarding the gang conduct. Um, 16, prohibit prosecutors' personal opinions. That one's granted. That's a pretty standard one. 17, prohibit mention of defendant silence. Is that even relevant, as she, I guess it looks like she was interviewed by law enforcement, right? She was initially interviewed for an hour and 22 minutes, and then she invoked her right to remain silent.
That's just a boilerplate.
Okay, so that one is moot. It's not an issue here. 18, prohibit cumulative evidence or arguments. I mean, it's granted without prejudice to readdress at trial as to specific items of evidence or arguments. Exclusion of statements from victim impact witnesses. I'm assuming that one should be granted. You're not going to be.
We're not planning on.
Okay, so that one's granted. 19's granted. Exclusion of inflammatory or prejudicial language. Terms such as gang member, killer, or criminal must not be used. I'm going to deny that one without prejudice to readdress at trial if necessary to specific arguments or evidence pursuant to my ruling on the state's motion in limine. 21, exclusion of references to media coverage. I've never heard the state talk about the media coverage in a case other than jury selection. So are you talking about during the course of the trial?
Yes, Your Honor. During the scope of all the depositions that have been occurring, literally all the officers have been saying that they're using YouTube as their source of information, and the bloggers, and they've even gotten very specific to name the ones to go to and the time sections in them. So we wanted to know the court's feeling on, the reliability of a blogger or.
What do you mean, as far as developing evidence in this case, they look to social media? I don't really understand what you're trying to keep out here.
I don't believe that a blogger, I don't believe that information that was posted on a blog or YouTube should be admissible, Your Honor. Because media coverage is difficult, because when you say media, social media and YouTube, but as specific that we want is for YouTube, as it portrays our client in a light that's not favorable, and as it portrays our client in a light that's just not true.
Okay, well, this is what I don't understand.
She's snitching and she's doing all this.
Are you talking about pre-homicide social media coverage or post-homicide?
Post-homicide, because it has a direct impact.
Well, why would the state even seek to introduce such evidence? Would you?
The detectives have been testifying to that.
Well, maybe because they were asked.
Judge, I don't foresee, and the only other issue is that I know that there was some deposition testimony regarding this investigation. Again, it goes how well known this feud is, and some of the investigation, they were referred from Jacksonville Gang Unit to the public media videos, and some of these drill rap videos, they're high production videos where they actually incorporate the news media of the killings
But
that
are
have
these
happened.
are these post homicide in this case?
No, I
Pre.
think they're pre.
Okay.
Unless I'm mistaken, that's the context where some of the detectives have talked about it. That again, it goes to their research into the motive of this case.
Your Honor, if I may, that's all incorrect. Actually, all the blogs and the majority of the videos, with the exceptions of some of the ones that the state has previously listed, but also with some of the ones they've listed, are all post the homicide.
Okay.
And because of the homicide is what encouraged the bloggers and more video and other videos.
Judge, I can say I'm not going to be introducing any kind of blog or any kind of stuff that occurred afterwards.
Okay. So it's because my understanding of as it's phrased in this motion, it says any discussion of news coverage of the case, which implies it would be post-homicide news. So this one is granted, again, without prejudice, to revisit if necessary at trial.
Okay.
But what I'm hearing from the state is they're only going to be seeking evidence before the homicide to establish the motive for this murder being gang-related. So I've granted it as to any post-homicide news coverage. All right, exclusion of evidence without proper chain of custody. Again, there has to be proper chain of custody. This one's granted without prejudice to readdress at trial if necessary. So if you think there's not a proper chain of custody, you're gonna have to make a contemporaneous objection and explain to me why. 23, exclusion of evidence obtained from improper searches. Again, this is general law, so it's granted without prejudice to readdress if necessary at trial, subject to a specific objection. (24) Exclusion of evidence based on spoliation. Do you have any spoliation evidence?
Here's the thing, Your Honor. There's been multiple testimonies as it pertains to like the completedness doctorate, where they're saying, oh, we weren't able to fully extract, or we couldn't get, all of her iCloud phone records, or well, that was specifically testified to and written in the reports.
But is it spoliation?
Well, that would be maybe a question for the expert, but we
Okay.
think that if it has been lost, destroyed, or modified in any sort of way, that it shouldn't be brought in.
Well, at this point, I'm not hearing an actual allegation of spoliation of evidence, so I'll reserve ruling, subject to revisiting at trial if necessary. 25, prohibit use of co-defendant statements against defendant. That one should be granted, right, State?
Judge, with the exception if it's a co-conspirator statement.
Assuming you lay the predicate.
Yes, Your Honor. But I don't intend on playing any of the other co-defendants' interviews.
Okay. All right. It's granted with the exception of co-conspirator statements, assuming the state can lay the predicate. 26, exclusion of evidence of gang affiliation. That one is denied based upon my ruling in the state's motion in limine. 27, exclusion of evidence of motive without corroboration. Prohibits, 28, prohibits speculative testimony about defendant's state of mind.
So that was more like about the inferences, and specifically inferences rather than just speculations, but literal inferences. Well, she must have been, she had to know, or her.
Okay.
friend
So
of mine.
again, that was granted without prejudice to readdress at trial if necessary. 29, exclusion of statements by law enforcement about defendant's credibility. That one's granted.
Judge, just again, there are statements in the defendant's interview where they question her truthfulness during the course of the interview. So again, I agree with the asking law enforcement any questions on direct. I wanted to bring that to the court's attention.
Except for any statements made by defendant during her post-Miranda interview.
Thank you.
There's Sue from that. Okay. Yep.
If I may, because the state has responded a couple times as it pertains to the course of the interview, because we don't have the full stipulation fully entered into the record, can we still, is the court willing to reserve on that? Because there may also be some other reasons in which it should be suppressed outside of the fact that they violated some of her constitutional rights and her right for an attorney. Because Miranda is a specific issue that's separate, that was not addressed or stipulated to, and I want to make sure that we still have the opportunity to bring that up.
Well, today was the day.
Well, the stipulation just occurred. I would have been arguing the motion to suppress, but then we did the stipulation, but then we don't. What was it done like yesterday?
Well,
and
the
it's
state has agreed that anything after the 1 hour and 22 second timestamp on the defendant's interview should be suppressed. So if there's anything else that you seek to suppress or redact in the first hour and 21 seconds of your client's interview with law enforcement, you're going to have to separately identify that.
Judge, I would object. There has been a deadline. It is their motion. They asked me to stipulate. We were prepared to go forward. There was never any other discussion when they asked me to stipulate to this. And Judge, I'm just concerned. I mean, we have a myriad of tasks that we need to do before this trial. And they're the ones that specifically requested for us to stipulate, and we forwent calling detectives.
AV Stat Media, all 4K.
Well, I'm assuming any objection they're going to have is not going to require testimony. Okay. So if you have any other objections to anything that your client said in her post-Miranda interview up until the 1 hour and 22 minute timestamp, I apologize, then you're going to need to file a separate motion as to that. And that needs to be filed by December 27th at 5 p.m. I'll take a look at it. Okay. So that's just a separate deadline that we need to add, Madam Clerk. So by December 27th, 5 p.m., defense also needs to identify any portions of the defendant's admissible post-Miranda interview they seek to have redacted. And then the state agrees, great, take it out. If not, I'll decide it before trial begins. Okay, paragraph 30, prohibit prejudicial comments during voir dire. I don't know what that means. So I'm going to reserve ruling on that. It's just subject to a specific objection at trial by either side. 31, exclusion of evidence of the defendant's association with certain individuals. Again, I'm going to deny that one based upon my ruling on the state's motion in limine. However, it can be denied without prejudice to revisit. As to
it's not otherwise covered by my ruling on the motion in limine. 33, exclusion of evidence of prior arrest or charges. It's granted, are you talking about just the Ms. Andrews herself or others, or?
Which one are you on, Your Honor?
32, exclusion of evidence of prior arrest or charges. And well, you say in your motion it's defendants, so that should be granted. Grant paragraph 32, exclusion of evidence of the defendant's prior arrest or charges. 33, exclusion of uncharged misconduct evidence. I'm going to deny that one pursuant to my ruling on the state's motion in limine regarding the gang evidence. 34, prohibit references to the defendant's exercise of constitutional rights. That one's probably moot, right? Because she waived her right initially to be interviewed. She was interviewed for an hour and 22 minutes, and then she invoked her right, and the interview was terminated. So that one seems moot.
Well, actually, Your Honor, that was more or less what I was trying to bring up before about our stipulation for the statement. It was more like a Miranda issue or a question for the court. And I'm not sure whether you still want us to address that per your earlier ruling or...
I don't know. What are you saying?
As it pertains to our client's
Are you going to seek to suppress the first hour and 22 minutes now?
What I want to say, Your Honor, is I do question the actual Miranda itself because of all the talking prior to it.
Well, listen, you just have to file a motion and I'll determine whether or not it's timely. It's not timely because I gave you a deadline and I said all motions had to be filed and today was the hearing date. So you just need to file whatever you're going to file, but at this point it's moot. Item 34 on your defendant's combined motion in limine because there's no motion pending before me anymore with regards to the defendant's post-Miranda interview. 35, exclusion of unverified or unscientific reliable evidence. Our reserve ruling on that one subject to a specific objection at trial as to specific evidence. 36, exclusion of evidence of the defendant's lifestyle or character traits. Our reserve ruling, subject to specific objections raised at trial. All right, that's it on defendant's combined motion in limine. Okay. Next up, defendant's motion to compel disclosure of testimony and evidence directly tied to Alicia Andrews. And has all the discovery been turned over? Are you saying there's discovery still outstanding, or what are you saying?
I believe this kind of argument may have intertwined more or less with what we were saying earlier, Your Honor. All the evidence that has been turned over, it's all intertwined so much so with the co-defendants. It's very difficult to make a specific determination as to what she's being accused of. Like we understand she's being, accused of being a principal, but the way it would be nice if the state were able to give us more specific reference. But since Your Honor did also already rule that we'll know who the witnesses and stuff are, I think that'll be helpful.
It'd be nice, but they're not required to. So they just have to turn over all of the discovery. They have to identify their witnesses and their exhibits, and then it's really all they're required to do. They don't have to lead you by the hand through the evidence as far as what their theory of the case is.
And Judge, we do want to make the court aware that discovery is ongoing, and we still are waiting for the FDLE ballistic results, and we will turn that over as soon as we have that.
May I make a comment about that, Your Honor?
Sure.
Or maybe even get some clarity? There was a motion that was filed, I believe, yesterday, not a motion, but a discovery amended discovery that was filed, I believe, yesterday, or early evening. But it was stamped for September 24th or September 25th. So we do want to make sure that if the state received this information in September, that we most definitely should have gotten it in September and not December. So I don't know what the state's stance is on that.
I can speak to that. It's an ATF DNA report during the course of depositions that were taken recently, and detectives specifically said that there was DNA testing that was done on some of the shell casings. I did have an ATF report that was 43 pages that I previously provided. I did not have this DNA results, which show that there were no DNA results recovered, but I did not have that laboratory report. It was literally emailed to my office yesterday, and that is why it was disclosed yesterday. It did have, I think the report date was September 13th, but I did not have that, and it was forwarded to me, the detective. It was sent to a supervisor in TPD, not the case detective, so it had to be located.
Okay. All right, that's your answer. Okay, so as to the motion, defendant's motion to compel disclosure of testimony and evidence directly tied to Alicia Andrews, I'm going to deny that motion as it's raised. So the state needs to meet all of its discovery obligation pursuant to the rules of criminal procedure. Defendant's motion to exclude evidence, testimony, or references to co-defendant's mental health or insanity defense. I don't think, are you planning on doing that?
No, Your Honor.
Okay, that one's granted. Defendant's motion to preclude use of guilt by association evidence. Again, in light of my ruling on the state's motion limiting as to the gang evidence, that one is denied without prejudice for defense to make a specific objection to specific evidence at trial. Okay, then I show the one we've got left for the defense is defendant's motion to permit confidential testimony of witnesses for safety reasons. Ms. Hurdle?
Yes, Your Honor. Due to the gravity, which has been stated several times here today and previously of what's at stake here, Your Honor, we wanted to know if Your Honor would be willing to consider, should we find reliable and credible witnesses to bring forth to the state, a certain procedure should they want to hide their identity or conceal their identity for safety purposes. And I'm not sure how Your Honor would handle that, or what.
Well, it has to be on a witness by witness ruling. So you, first of all, you'd have to identify who the witness is. Now, if there is a concern, you have the same as it is for the state. The state has got witnesses that they're going to have to call to testify. They're going to have to take the witness stand, and their name is going to have to be identified. Okay. However, I would consider for both parties, if there was a particular witness that had legitimate safety concerns, things like asking the media not to show the witness's face while they're testifying, asking the media or entering order that the media cannot disclose any personal information about the witness. Potentially, I could ask that all of the people sitting in the courtroom that are just visitors be excluded during a particular witness's testimony. And things like that I would be amenable to, but it'd have to be done on a witness by witness basis, and you'd have to convince me why it was necessary.
Your Honor, would you be willing to consider a remote, as in not located in Tampa, if it was a family member of my client?
No.
But you would be willing to consider the other things that you just mentioned?
Yeah, absolutely. And if a witness thinks they need to be escorted to and from their vehicle, I can talk to law enforcement about doing that as well. But no, I'm not going to do remote appearances. Everyone's got to come to court and testify in this case, absent a true exigent, unanticipated emergency that would result in the trial being delayed. True. Okay, so I'm going to reserve ruling on that one.
Thank you.
And then you guys just let me know as we go along if there's a particular witness, what your concerns are, and then I'll address it.
Judge, if I could on this
Yeah.
motion. So, only because of statements made previously by counsel about this motion, there's no reason not to provide to the state the name and the identity of
Yeah,
the
no,
witness.
and we're gonna talk about that. So on your witness list that's due by December 27th at 5 p.m., if you have concerns about a particular witness in the court filing, you have to identify them by name. You have to put the name. However, the other information, you can put in your filing, your copy that goes to the state as far as their, what you're required to do by the rules, their name and last known address. And however, you have to put in a certification that you are contemporaneously advising the state as to the address for the witness, okay? So you identify the witness by name, that has to be public record, you have to put that, and then put a certification for any addresses you're withholding due to safety concerns. You have to certify that you are contemporaneously providing the state with that information. Fine?
Thank you.
Okay, that's all I have for today as far as motions go. All right? So, yes.
Can I see clear? I know we went through a lot, and thank you so much for your time today.
Sure.
I feel like you're very fair.
That's what I get paid to do. Ask Mr. Gonzalez.
I do want clarity because it went by a little fast and it was earlier. On one of the state's motions earlier, or motions of money earlier, as it pertains to information that's equally available with the witnesses.
You cannot, neither the state nor the defense can comment in closing argument on the other side's failure to call a witness as long as that witness is mutually available. Now, if a witness is solely within the state's ability to produce or solely within your ability to produce, then it is fair game to call out in front of the jury why that witness wasn't called. And this really rarely ever happens.
So, can I ask a follow-up for that, Your Honor? Because I actually feel like we're having an issue with that. And it matters because it's as it pertains to the Airbnb, and I have actually asked the state this before, and the officer in depots, for the specific identification of the girl that they're saying that communicated with my client with the Airbnb. And now her Instagram or all her information's gone, but they don't have a name to give me for me to be able to reference her.
I'm not sure what you're referring to. So you're going to have to talk to the state about it to see if you can't figure out a resolution. And if it needs my intervention, you have to file a motion to let me know. I honestly don't know what factually you're referring to. I listened to the pretrial detention hearing evidence, and that's all I know about this case.
It's an Instagram message wherein they're saying that my client was trying to book the Airbnb with someone else, but the someone else we don't have an identification.
Talk to Ms. Doherty about it afterwards. Okay, when we're done here, and see if she can't identify for you who that person was. Okay? Okay, so as it stands now, we're set to begin selecting our jury at 9 a.m. on January the 6th. How many jurors do you think we're going to need? Mr. Harmon?
At least, I would say at least 70.
Okay. Sound good to you?
Yes, Judge.
Okay, so 70. And then the trial itself, how many actual days of evidence? 3?
We're just discussing, Your Honor, maybe 5 days of testimony outside of jury selection and opening statements.
It won't be 5.
Well, we're trying to be conservative.
It may be 4. It may be 4.
We'll try to pare it down. It's just hard to estimate, Judge.
I know. Attorneys are notorious for overestimating how long it takes to try their case, for the most part.
Yeah.
But as far as the jury's availability, I would probably then ask for people to be available for the following Tuesday, the 14th, just in an abundance of caution. Okay? And I'll be around. If something flares up and you guys need to get before me or need to talk to me, I'll be available. So I'll be available January 2nd and January 3rd. So just contact my office, and I think we're open on the 2nd. Are we?
Yes.
Okay.
Yes.
Yeah. So I'll be around. All right?
Yes, Judge.
Okay, everybody. Happy holidays, and let me know.
All right, so I thought that was a pretty good. That was a really good, informative hearing. We found out about how many jurors they were going to select, how long they thought they were going to take in the process. Went through a bunch of motions. Yeah, I thought that was really good. All right, I have one more, and then we're going to break for lunch. Don't do that. Come on, he's sleeping. Stop it. Rafa's literally sleeping, and Superball goes up and smacks him. You okay, buddy? Yeah, good boy. Why? Just why? Just go over there. Go to your corner. She's such a brat sometimes. Wizard of Ezzy, I enjoy watching motion practice, sometimes more than the trial, because more tea is spilled. That's true. That is true. I think I'm going to have to come over here now. Let me just close this up a little bit. Yeah, no, I agree. I agree with that. You definitely, and they're more relaxed, they're like more relaxed, and they let things fly a little bit more. Like what Judge Sisco said, that's what I get paid for. Just ask Mr. Gonzalez. That to me right there shows that
I did get an email saying
that she is comfortable with, knows the local lawyer, so I kind of thought that from the beginning. When I found out that Alicia's lawyers were from Miami, I'm like, oh, I wonder how that played, with the sparring and the sparks going back and forth versus the other four, where all those lawyers were local, Tampa, have been in that courthouse, multiple times, many times. So just interesting. All right, so this is another Alicia hearing. This is from January 3rd. So this is from January 3rd, another hearing for Alicia. So hearing for Alicia on January 3rd. So this is like a month before she gives birth. Right? She gave birth, her due date, she said, was February 16th, I think, 15th, 16th. I think they settled on the 16th. So yeah, all right, let's hear what this is about.
She's stuck in traffic. I think Connie might have, Jay might have been copied to it, not yourself.
Okay.
But saying that she's stuck in traffic and on the way.
All right. I'll let Mr. McLymont know. He's appearing via Zoom, so.
Cool. Say Ruby.
Go. I'm gonna hold on one second. I was having trouble finding the icon. We're just waiting on Miss Hurdle. I think she is stuck in traffic on her way here.
Okay, Judge, that's no problem.
Okay, so as soon as she's here, I'll be back.
Okay.
Ms. Hurdle is present. Ms. Andrews is present. Mr. McLymont is on Zoom. Who's going to be arguing this motion for the defense?
I am, Your Honor.
Okay, you may proceed, Ms. Hurdle.
Yes, at this time, I to obtain the bench.
Oh,
Okay, let's say that.
yeah, right. I'm just trying to think, there's no way for Mr. McLymont to participate in this discussion. So does he need to be?
Probably not. It's okay.
Okay, Mr. McLymont, Ms. Hurdle has asked that, to approach the bench. So I'm going to let her, but there's no way for me to allow you to participate, to keep it confidential since you're on Zoom. So.
That's fine, Judge.
Okay, very good. So I'm back, Mr. McLymont. So this was Ms. Hurdle's motion to continue. And Mr. McLymont, had you filed a motion to withdraw?
I just filed one to withdraw, Judge. I'm withdrawing the motion to withdraw.
Okay, so you're going to remain as counsel.
Yes.
And are you adopting the emergency motion to continue trial?
Yeah, I did file a waiver of speedy trial, and I will be adopting.
Okay, so I will,
Just on dissipation.
okay. So I will grant the motion with the waiver of speedy trial. And Ms. Hurdle, do you have a motion at this time?
Yes, Your Honor. At this time, I am making a motion to withdraw.
Okay.
As counsel.
And Ms. Andrews, you understand what's happening here? Okay, so Mr. McLymont is going to stay on as your counsel. Ms. Hurdle is going to withdraw as your counsel. And due to that fact, there's no way they could be ready, Mr. McLymont could be ready for trial on Monday, as this case is currently scheduled. Okay, so then he has entered a waiver of speedy trial on your behalf. So I do want to get a new trial date on the calendar because I know the attorneys for the state are very busy. This court's busy. So Mr. McLymont, do you have your calendar handy?
Yes, Judge.
Okay. So I can tell you all, I don't have any availability currently until August. So let's start with the state, and it would probably be August 18th, August 25th, somewhere around there. Let's say the 18th.
Judge, I would be fine if we started on the 18th because I have another homicide trial on September 8th.
Okay.
So as long as, yes, if we started on the 18th and had 2 weeks, I think that would be fine.
That's also fine with Mrs. Her and myself. Right?
Okay. And Mr. McLymont, how are you looking then? Okay. And actually, because we're going to need, how many jurors did we say we're going to need?
70.
70. Oh, we're fine. Then we can keep it on the 18th. All right. So then we will go ahead and reset this case for trial beginning Monday, August 18th at 9 a.m. And I'll set us.
Now, you heard that August 18th, and Aaron just came in and said it was Miss Doherty who had some kind of medical emergency or something happened, something happened with her. We don't know what, but they had to push it from this August 18th to October. That's why they started in October. So that's just a little nugget of information.
Aside 2 weeks and reset this case for trial beginning Monday, August 18th at 9 a.m. And I'll set aside 2 weeks. It's not going to take a full 2 weeks, but in abundance of caution, I'll set it aside. But I'm thinking it'll be more like a week and a day or a week and a 2 days max. So we have a status with the other defendants, I think. Let me look here. March 31st at 10 a.m. So we will set Miss Andrews for status as well. And for that hearing, Mr. McLymont, if you would like to appear via Zoom, you can. You just know the drill. You got to let me know ahead of time.
Understood.
And then if for some reason that status, if an evidentiary matter has to be heard on that date and time, then obviously you'd have to make the trip up from Miami if it involved your client. But if not, if you're just appearing just for a status to check in, then you can appear via Zoom. Okay. Is there anything else that we need to discuss?
Confirm, we've been working on witness and exhibit lists. Can we strike that they be done by today?
Yes. Okay. I was going to enter an order and the order will have in it the dates that I ordered at the motion hearing. But obviously you guys will know, since the case is being continued, that the court's instruction that you all have your witness and exhibit list done by 5 p.m. today, that is now stricken. Okay. All right. Anything further from the state?
No, Your Honor.
Anything further, Mr. McLymont?
No, Judge.
Okay. All right, Ms. Hurdle, anything further? Okay. All right, very good. We're concluded. Thank you.
Court's adjourned.
So that was a rather pregnant Alicia walking out the door. She literally was a month away from giving birth. So that was Alicia, pregnant Alicia. Did we see her coming in? Oh, we do see her coming in. All right, here. This is okay. This is her pregnant. This is pregnant Alicia. She was like a month away from giving birth. So. A month away from giving birth. All right, you guys, that's it. She was sentenced. She was sentenced. If you missed it, go back to, let's see, if you're hearing my voice right now, when was she sentenced? It's about 3 hours. Now, it's been about started about 3 hours ago, 3.5 hours ago. And then she was sentenced about 3 hours and 20 minutes. Yeah. So it's been about about 3.5 hours now. Roughly 3.5 hours ago, she was sentenced. Excuse me. Aaron did a short. If you want to check out the short, or if you want to go back here, we'll make a video maybe later today. We'll just do a video specifically of just her sentencing, and we'll upload that. So if you want to just see that. So flesh this out. She pled. No, she didn't. No, she went to trial. She did not take a plea. She went to trial. She got the lesser included, which was manslaughter, and now she has to spend 15 years. 15 years. It did take about 2 nanoseconds. It did. It was so quick. Yeah, Kaylee, if you blinked twice, you've missed it. I'm like, I was like, what? Sentencing? What? I thought it was going to be like, okay, no new trial, and sentencing will be set for, like, where were victim impact statements? Well, Cedricus Mays gave an impact statement, and that was it. And then the defense had nothing. There was nobody that came up to talk on her behalf. Unbelievable. Just shocking. Especially coming after Paul Canero's sentencing with Judge Lemieux talked for like 2 hours, went through every charge, everything. High detail, great detail. And then this was like literally probably 15 seconds, 20 seconds. Just boom. So anyway, Judy, you missed the entire case. That's all right. All right. Actually, that's going to be it for this case. Other than the sentencing of the guys, they're going to be sentenced June 22nd. And then we're going to put this trial to bed. It seems like, unless there's an appeal, all that stuff, we'll keep an eye on that. But really, the next time you'll see us covering this trial will be June 22nd. So Yeah, there was. I think it was first degree. I think it was first degree, and then the lesser included was manslaughter, and the jury ended up on manslaughter. So it is, yes, horse welfare. It is a short. Virginia, you're going back. You were sleeping at that time. No problem. All right, so we're going to end our coverage here. We're going to take a break. It's Pizza Friday. We're going to go have some pizza. Got to feed the kittens, and then we'll be back at 1:30. Got 1:30 for the cross of Alex Murdaugh. So join us for that. Oh, you know what? Let me put a redirect on. I can do that for you guys, so you don't have to do anything other than just take the portal. Let's add a redirect here for you. Boink. There you go. There's a redirect, and also here is the Alec. It's an ego takes the stand. Alex ego stream. All right, so there you go. So join us for that. Oh, she was tried on second degree? Okay. Let me see. What was Alicia Andrews charges? Not chargers. Premeditated first degree with a firearm and conspiracy to commit premeditated. Huh. You guys are here in second degree? All right, here's, let me see what this is. I thought it was first degree. Yeah, she was tried on first degree, you guys. Yeah, same as the guy. She was tried on first degree. Yeah, she was charged with first degree and then conspiracy to commit. It was first degree and conspiracy. She was convicted on manslaughter. Wait, what? Alicia Andrews, found guilty of the lesser charge of manslaughter, was charged with first degree and conspiracy to commit. I don't know. Whatever. Let's put a pin in it and talk about it. So join us for Alec Murdaugh. Ego takes the stand. We're going to get into his cross. So thank you for joining us. Thank you to our mods. Thank you to Aaron. And I will see you guys hopefully at 1:30. Okay, take care, guys.